I'm calling to order this public hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Tuesday, January 13th, 2026. The time is 11:31 in the morning, and we are in room 412 of the John A. Wilson Building. This is the first of three hearings that the Committee of the Whole is having today. This hearing is on Bill 26-325, which is entitled Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025. This legislation was introduced on July 11th of this year, and the stated purpose of this bill is to clarify the Board of Ethics and Government Accountability's ability to require certain individuals to file public financial disclosures. BEGA, the Board of Ethics and Government Accountability, administers and enforces the district government's code of conduct and the laws that promote an open and transparent district government. BEGA includes two independent offices, the Office of Government Ethics and the Office of Open Government, and a 5-member board. The BEGA was created in 2012 through the Board of Ethics and Government Accountability Establishment Comprehensive Ethics Reform Amendment Act of 2011. Since then, numerous boards and commissions have had to comply with disclosure filing requirements. But in September 2024, BEGA identified approximately 45 additional boards and commissions as containing members that BEGA considered necessary to file annual financial disclosures. BEGA took this action pursuant to the law, adopting a rulemaking, but provided little, if any, rationale as to why it was necessary that these boards and commissions be added. Conceivably, it was acceptable until recently that the mostly volunteer members of these 45 boards and commissions could function without disclosing personal financial information. The council acted in May 2025 and in December 2025 to delay the implementation of these expanded financial reporting requirements until the council could take an opportunity to consider the issue more fully through a full hearing on this permanent bill, which is what we're doing today. So we will be looking at the reasoning behind adding 45 boards and commissions to these disclosure requirements. Let me turn to colleagues to see if they have any statements, and then we'll go to witnesses. Councilmember Henderson, do you have an opening statement?
Yes, thank you, Mr. Chairman, and good morning, everyone. So a number of the new boards and commissions that were added under the Bacon ruling happen to actually fall under the Committee on Health, which I chair. So the Board of Dentistry, Board of Medicine, Board of Nursing, et cetera. What is, I guess, uncommon known, while these are, yes, voluntary positions, and I do thank everyone who serves on our public boards and commissions, particularly our professional licensing boards, what the public may not know is that these individuals also have significant power over someone's licenses in that they review complaints and investigations. They can suspend someone's license. They make decisions around scope of practice, et cetera. While we do significant amount of oversight with our boards and commissions, since I've been a member of the committee, these questions around conflicts of interest and financial disclosure are ones that I think are probably worth acknowledging for transparency's sake. And so I'm interested to hear more from BEGA, and thank you for holding this hearing today, Mr. Chairman. Thank you.
Thank you, Councilmember Henderson. Councilmember Fruman?
Thank you very much, Chairman Mendelson. I'm looking forward to hearing the testimony. As you set it up, there's been a discussion about adding a whole bunch of people under these requirements, and there's a long list, and the list, it may be different for different entities on the list in Cantor, but the question is, what is the burden that folks will face, and what is the benefit that we get from the transparency around financial disclosure in each of these contexts? And I've heard different claims to date, but I'm looking forward to hearing the testimony today. And I am a filer, and it is a nuisance, although not a giant nuisance. So the question is going to be whether or not this extension of requirements makes sense in each of the individual cases or not, and look forward to hearing from the people closest to it about their views on the topic. Thank you.
Thank you, Councilmember. So the witness list, we have three individuals before we get to the government witnesses. So I'm going to call the three at once. Robert Vincent Branham, Eric Jones, who's Vice President of Government Affairs at AOBA, Apartment and Office Building Association. Kedrick Payne, who is Vice President and Senior Director of Ethics at Campaign Legal Center. So we have a clock, but we don't have a lot of witnesses. So I'm going to be a little loose until you get to be about 12, 15, 30 minutes. And then when you hear thumps, that's because we're falling asleep and you've gone on too long. Mr. Branham, you're first.
Greetings and salutations. I testify in opposition to this bill. This measure, as written, does not clarify accountability. It serves as a curtain for which unsuspecting and unintended decisions can be made. I am not a Trump MAGA, but I am a DC Baker. The people, citizens of the District of Columbia, have expectations for an open government and have expectations of trust for a transparent government. The dual concepts of expectations for an open government and trust of a transparent government may blow some people's minds, but like Gabriel's trumpet, the truth has to be sounded. Baker's ethics rules are regulatory oversight warnings to district government officials elected and appointed. There is judgment against conflicts of interest and ethics violations. The striking of this rule runs counter to open government and transparency. Citizens do not expect public employees to rid themselves of all personal privacy, but citizens do not expect to be governed by impermissible and unwarranted secrecy. There are instances where privacy is overwhelmingly important, such matters relating to children, sexual abuse, and domestic violence. Privacy is also important in criminal cases, investigations where criminal charges are not presented or found to be meritless. This rule does not involve those criminal actions, rather decisions of conscience in the name of public service. It is understandable and right for the people of the district to expect public servants to give great weight to avoid the appearance of conflict. The passage of this legislation could, would, and may create a loophole of unintended consequences relating to influence peddling and bribery involving other district government employees and elected government officials. This rule change invites outside interest organizations and persons to feel free to approach any and all district employees regardless of position level or self-dealing. I have filed financial disclosures. Financial disclosure is intrusive, but it is designed to protect the public and to reveal the official open to corruption. It serves as a notice to property with propriety and righteous due diligence. Public servants are commended volunteer public servants and should be praised, honored, and respected. While it may be the purpose and intent of this legislation to carve out covered personnel from financial disclosure, this legislation restricts Baker from responsible ethics oversight and holding accountable all district employees, officers, and elected officials. I urge the committee not to approve this legislation. However, Mr. Chairman, before I leave this table, I must speak in response to one of your colleagues, to me. I am a service-connected disabled veteran, and I deserve to be respected. I have been arrested twice in this city for home rule and DC government. I have testified before this council on budget and oversight and for the people seeking council confirmation. I have served as a city employee, agency commissioner, and other community organizations. I have given my blood, sweat, and tears. I have been physically threatened, bullets coming into my home, forced to leave under police protection. It is an insult that one of your colleagues would say that I do not have the intellectual capacity, gravitas, to process and understand the nuances of the DC budget and unqualified to sit with you on the council as an appointed person temporarily. This is not just an opinion from certain members of this council, but it's also something that comes from certain members of the press. I find it insulting and disrespectful for me, for my service to this city, that I have to be told that I do not have the intellectual capacity to understand the budget, to read, to count. And I find it offensive.
Thank you, Mr. Branham. Mr. Jones. Mr. Branham, are you getting up from the table?
I'm leaving.
Well, hopefully I'm not suggesting that you're unwelcome. Because that's not my view at all.
I'm not talking to you. I know that. Wouldn't have directed at you.
Mr. Jones.
Hello, members of the Committee of the Whole. My name is Eric J. Jones, and I'm here today as a fourth-generation Washingtonian and Ward 4 resident who also has the honor of serving as Vice President of Government Affairs, DC Commercial for the Apartment and Office Building Association in Metropolitan Washington. For more than 50 years, the AOBA serves as the primary membership organization for commercial office buildings and multifamily residential real estate in the greater Washington, DC area. As an organization, our members own and manage over 150 million square feet of commercial office space and more than 450,000 residential units across the region. In the district, that includes roughly 120,000 apartment units and over 75 million square feet of commercial space. I'm hereby submitting this testimony in support of B-26-325, the Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025. Just a bit of background. In spring of 2024, BEGA issued a proposed rulemaking designating an additional 47 boards and commissions as required to file financial disclosure statements. Within those proposed rulemakings, BEGA advised that government employees who make decisions or substantially participate in areas of contracting, procurement, administration of grants or subsidies, policy development, land use planning, inspections, licensing, regulation, or auditing, or who act in areas of responsibility that may create a financial conflict of interest or an appearance of a conflict of interest should file a financial disclosure statement with BEGA. Following the notice, several AOBA members who are currently serving on boards and commissions, some of whom recently had been reappointed by this body, were informed that the groups they served on were included in the new list of 47. This was problematic because not one of them had previously been required to file, and all would have resigned or rejected their reappointment if they had. Additionally, on April 25th, 2025, I submitted an official statement via email to BEGA Director Ashley D. Cooks attached to this testimony highlighting our concerns. Two of our members who are on the Construction Codes Coordinating Board also submitted the required waiver forms. They noted on these forms that the documents provided by BEGA reference only DC government employees and elected officials. Subsequently, Director Cooks rejected both appeals and offered no guidance on how non-government employees were to complete forms not designed for them. She also informed them that if they resigned immediately, they would still be required to submit those financial disclosure documents for the year, even though it had just come up, and they would be fined if they failed to do so. Even though they were given no ability to voluntarily decline to serve in such a position, especially considering that the positions are unpaid. Now to the legislation. While BEGA is falsely attempting to characterize this legislation as a means to restrict its ability to require oversight, this is not the case. Instead, this legislation aims to hold BEGA accountable for A, failing to engage in clear ethical oversight through dialogue and feedback from the public, B, provide the appropriate forms of submitting information, and C, properly reviewing appeals and providing relevant feedback and opinions on submitting questions. Conclusion, while we at AOBA fully understand and support open and honest government, we believe that the aforementioned actions by BEGA represent an extreme overreach. Moreover, they send mixed messages to the public. As we continue to engage in various forms of public advocacy and civic engagement, we will continue to share our thoughts and feedback on all aspects of government and are open to answer any questions you may have. Just in 10 seconds, sir, as a registered lobbyist for the last 18 years, I've been required to file every year. I can speak personally to the fact that during the COVID-19 emergency, people found my information based on testimony I provided. My vehicle received 6 flat tires in 8 weeks in front of my home because of testimony that I provided or recommendations based on the work that I do. I fully understand the danger that comes with the work that I do, but it is my choice. Telling someone who has not volunteered for that you're forced to provide that information or face a penalty is inappropriate. Thank you.
Thank you, Mr. Jones. Mr. Payne.
Good morning. Thank you for this opportunity to appear before you and to speak on this very important topic. My name is Kedrick Payne, and I'm Vice President and Senior Director of Ethics at Campaign Legal Center. CLC is a nonpartisan, nonprofit organization based in the district that is dedicated to supporting strong ethics laws and protecting public so that they are able to have confidence in government institutions. And that's why we're here today, because this law seems to do the exact opposite. It seems to harm public trust in government. My written testimony has more details, but I'll provide 3 problems that I hope that this committee considers in order to determine whether it would approve this bill. First, this bill harms BEGA and the public interest. BEGA was created so that it could give the public confidence that there is an entity that looks at conflicts of interest for public servants that enter the government. And that applies to volunteers as well. Volunteers are covered by the conflict of interest laws. The logical first step to find out if there's a conflict of interest is to know whether you have financial interests that conflict with serving the public. You cannot do that job effectively if you're unable to require and determine who files those financial disclosure forms. By having this law, you rip away a core function of this agency. More importantly, you create high-risk individuals, those that are responsible for the decisions related to procurement, government contracts, subsidies and grants, and other financial decisions have to be reviewed to see if there are conflicts of interest. Second, this law undermines the Government Ethics Act. The district created a law so that it could provide transparency to the public so they can know potential conflicts of interest of public servants. This creates a transparency gap. You have people entering government where there is no way to know if they have conflicts of interest or how long they have them. These include the volunteers that have been in office for a while. There's a blind spot to know whether or not they already have conflicts of interest that could affect the decisions that they are making. Third, this law does not consider alternatives. It is like an axe instead of a scalpel. If you have people who are concerned about safety, property damage, etc., they should be able to follow the law as it exists now, to have an exception to the law where they file their financial disclosures confidentially. That way, the ethics office is able to review and find any conflicts of interest, but you no longer have the threats of anyone who is a third party who wants to cause harm and do anything that could be a violation. So in conclusion, we respectfully ask that this committee reject this bill and continue to support BEGA in this mission to give the public confidence and trust in government institutions. Thank you.
Thank you. Thank you, Mr. Payne. Thank you, Mr. Jones. I do have a few questions. Let's see how long I take. And then maybe I think primarily to you, Mr. Payne. I didn't understand how this bill harms BEGA. Now, you talked about the importance of ethics and disclosure, so you could make the argument that it harms disclosure or transparency, but you said it harms the agency.
Yes, that's correct. So based on my experience at CLC, we look at the state and local ethics commissions across the country, and we look at what their functions are, what best practices are. When it comes to financial disclosure and to compliance with financial disclosure, ethics agencies must be able to determine who files those disclosures. Because if you're not able to have the power to determine who does that, then you can't truly enforce the law. So in this situation, it harms BEGA because if they're supposed to enforce the law, but they don't have the information to do it. And they also don't have the deterrent. I should point out that this ability for Bega to find out and determine who has to file these disclosures serves as a deterrent for those people who would enter public service for the wrong reason, that is to support their own financial personal gain as opposed to serving the public.
So I assume you're familiar with the disclosure questionnaire that Bega has. So what questions on there are helpful in terms of understanding ethics on these members on these boards and commissions?
Anything that helps the agency, Bega, know what their potential interest may be.
That's not going to do it. I want to know what questions are helpful to identifying disclosure. So for instance, if I remember correctly, one of the questions is, where do you live? Another is, what property do you own?
Well, one of the law, well, with some of these boards and commissions, they do have requirements that you live within the district. So to determine whether or not you have compliance with that it is relevant. Also, I would point out this, if there's a particular
So
commission.
do you really think that an individual who is violating the law and required to live in the district and is not living in the district is going to truthfully report that on the form that they don't live in the district?
They may not, but if they don't report, that you have cause to show that they have violated the disclosure requirement, and then they're liable for telling something that is false on that form.
They
This
also
is
they also could just be fired for being disqualified because they don't live in the district if they're required to live in the district. I'm not getting what the form adds there, but there, if I remember correctly, something like 15, 16 questions. My question to you is, which of those questions is helpful with regard to understanding whether there might be an ethical violation for a member of some of these boards and commissions? And please don't talk to me about council members, because that's not an issue here,
Mhm.
or about some of the boards that aren't subject to this legislation. Talk to me about the ones that are.
Sure, I don't have the list in front of me, but I do know that the whole point of the financial disclosure form is for them to list the interest. So each question that is on that form should relate directly to potential interests they have related as financial assets and things of that nature, so that you can determine whether there are conflicts.
I'm not feeling it. So
Is there a particular question?
let me ask you this. Why, it's a bit of a setup question.
Mhm.
I'm guessing you won't know the answer. Why are we requiring a disclosure form for Bega for the DC Retirement Board?
The based on the law, these distinctions are made based on those entities that are related, that are involved in policymaking. It can be
All right, that's not helping me.
contracting.
So it was a setup question, and the reason is because the retirement board already requires disclosure forms for each of its members. So why is it necessary for Bega to require a second disclosure form?
Chairman, what you are pointing out is what I was trying to make, which is this: if there are particular parts of the agencies that have been highlighted that should not be covered, then the process is to then to say that these people should be accepted. It is not to completely sweep away the power of this agency to find out financial disclosures for those entities that should be
So
covered.
you are saying that there could be exceptions.
Absolutely.
So what about, and maybe that would be the answer here, for like, why do we want to know, have a disclosure for volunteers on the District of Columbia State Athletics Commission, which is totally advisory, or the Interagency Council on Homelessness, which is comprised of government officials who are already filing disclosure forms? Why is that helpful? Or the Interstate Commission on the Potomac River?
That question you're asking is part of what the rulemaking process that was in the law should have answered. For all of those entities that had been identified who did not want to be covered by this, they had the right and the process to publicly explain why they should not have been covered. If now that is a problem, then they can file for the exceptions, and then you can do it that way. But completely sweep it away, this power, is an axe where you need a scalpel. I don't disagree that there could be many exceptions there. That's not the point that we're trying to make.
Thank you. Councilmember Henderson, did you have any questions?
I do, Mr. Chairman. So I went through the list, and like I said, I chair the Committee on Health. So there are some boards where I'm like, okay, that makes sense. Now, Mr. Jones, the AOBA board members who let me back up. Is the concern that the questions are too invasive or that they would have to respond at all?
It's not that they're too evasive. So there's certain information some of our members don't want to provide. Because there's several things that are being left out. This is not a fair choice. I can personally name 5 boards off the top of my head, one of which I'm on, that I had a meeting this morning, where the chairs or vice chairs of the board represent companies that are directly benefiting from decisions being made by the boards.
Yeah.
None of them have been included in the original BEGA list or this list of 47, and BEGA is not considering including them. This was a random list. Now for the CCCB, they're members of our board who are appointed based on their expertise, who own property or own other interests, but this also includes their spouses. And so some folks don't want their spouse's information made public. That's just something that they have a decision to make. The problem we had is that this decision was made in September. And they were told in September that because they served on a board and a decision was made in September, that they have to go back and then file for something that they were never made aware of. One gentleman's been on this board for nearly a decade.
Yeah.
Now, if he's being told a decade in, this is now a requirement and you have no choice but to file all this information or pay a penalty, he should at least be given the right to resign. He would not be given that right. BEGA told him, you can't resign. You have 2 options. You file or you pay. That was the only option. That is where we have a problem.
Okay. I mean, I see where your issue is in some ways administrative, and to the point that CLC is sort of raising, I could understand, whereas it does seem as though we're taking a hatchet where a scalpel can potentially be used. So like, for instance, let's take the example that the chairman gave around the DC Athletic Association. Anybody who understands about youth sports, you're like, okay, it might be good for us to know whether or not someone who's on the athletic association is also receiving money from an AAU team or Nike or
I
whatever.
asked that information prior to getting on those boards. I've currently served on 5 boards and commissions in the district.
Yeah.
Most of the information that will be provided via disclosure statement, except for my individual assets, is already asked of me before my name goes before this council.
Yeah, but how long have you been on those boards?
One of them I just got appointed to in September of last year.
Okay. Has there been any point on the 5 boards that you've been on where somebody has asked you to update the information from your previous conflict of interest form when you first signed on?
Well, I've had to do it randomly when I've gotten reappointed. Most of them are 2 or 3 year positions.
Okay.
So there's one thing to be reappointed, but if I'm sitting on a specific position for 5 or 6 years, that's different than every 2 or 3 years I have to fill out that information.
Yeah.
So that was what I mean by I was also given a decision. I was asked if I'm willing to do this. I was not asked if I was willing to volunteer to do this, and then being told a year later, 2 years later, you now have to give all this information, because some folks will not do that. And that's the piece we're not looking at, but also the fact that we have to find a way to make this make sense. The fact that we have people who are senior directors in companies that directly benefit from decisions that they're pushing, and they're not on this BEGA list, and BEGA hasn't looked at them, is problematic.
I think I think you're bringing up a fair point, but the legislation at hand would essentially say, BEGA, you can't add anybody to the list. And unless legislation establishing said board or commission requires financial disclosure, it's not a thing.
And my problem is until BEGA comes up with an open and honest and transparent way of doing it, they shouldn't be allowed to. Because we've seen when they've been given the discretion, they reject any appeals, they reject any decisions, they don't give opinions, and they say, do it our way or else. That's not transparency.
That's the question, though, in terms of my understanding is that the regulations were published and that there was opportunity to provide public comment. Is that no longer a transparent process?
Not when the original recommendations did not specify what BEGA laid out in the final decision. So that's the problem. So for example, the 2 individuals from the CCCB were originally told they wouldn't be required to file disclosure. So there was no questions. The question came when BEGA came back and said the entire CCC board is required to use a form that designates that you're only a DC government employee or an elected official. And when they asked about how does this differ, they said, figure it out.
Okay. Let me ask, you didn't put us on a clock, so, we're here. Let me ask this question. in terms of other jurisdictions who have the financial disclosures and Board of Ethics and Accountability, do they have better systems of sharing information amongst one another? So for instance, what the chairman said about the retirement board that fills out a conflict of interest. I also know that the mayor's office of talent and appointments might send a questionnaire to a nominee prior to their committee process, et cetera. I too don't like folks to have to do the same thing 3 and 4 times, but rather if that information is already done in one place, why can't it be shared with Vega? Can you talk a little bit about why Vega's form has to be the form as opposed to where else the information might exist?
Yes, typically the way that you have the agency in charge of it is the agency that's responsible for making it public. So if that agency, like Vega in this situation, is responsible for publishing the financial disclosure, they will be responsible for the one that acts and solicits that information from the public officials. Is that answering your question, or are you asking something else about how it's coordinated?
I understand in terms of the public disclosure piece. What I'm trying to get at is that if the information already exists, because you already had to provide it, is there harm in, say, the retirement board sharing the conflict of interest or financial disclosure information that they already have with Vega? Why would someone need to fill out both forms?
Well, you need to fill out, it could simplify the process to have the information shared, but you still would need that public employee to fill out the form and sign it, because that creates the accountability for the form that was created.
Okay, but you said public employee.
mean,
And these are not, right? I get it for government, council, et cetera. And again, I'm trying to find where the needle is here, because I understand that these are voluntary positions, but these are voluntary positions that also have significant power and authority within the construct, right? So, yeah.
The thing with your volunteers that may be distinct from others is that your volunteers are subject to the conflict of interest laws. So even though you're volunteer, you're not paid, you're subject to these conflict of interest laws that draws you into this jurisdiction of Vega. But let me point out one very important point. To the extent that Vega's designation is not liked and there's a different way you want to do it, this law doesn't accomplish this. What this law does is sweeps out anybody being able to designate who's going to be covered, including the people that you pointed out that should be covered. You have to have an alternative in place before you just sweep out what the current process is.
Yeah. Thank you. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Fruman, do you have questions?
Yes, thank you very much. Hopefully not too many. Mr. Jones, at first I was puzzled about the idea that there were people who didn't have a choice, but I guess the question I think becomes whether this is a retroactive requirement or a prospective requirement. And I think the point you were making, and correct me if I'm wrong, is that for somebody who's been on a board for 10 years, you can't tell them in year 10, submit forms for all those back years, and you have no choice because you have to cover it. But if the requirement was for the boards that have been added, that they must begin to submit financial disclosure in the next calendar year, would that solve the problem for you?
It could, and we proposed that and Becca rejected it.
Okay, so that's why I was trying to understand, there's different boards, there's different things. How big's the burden? How big is the benefit? And the burden, if it is retrospective, gets bigger. And the benefit of having that for the back years, open question to me. So that's why the back and forth here. But that could help you significantly if it was prospective only. On the idea of doing multiple forms, I mean, I wonder whether in other places there's a standardized form so that other entities inside of the government that have disclosure requirements use a form that is very similar to whatever the lead ethics office is. Is there coordination in disclosure across agencies in other jurisdictions?
Yes, yes. There are situations where you don't have to completely follow the same form over and over and have the same information produced in different versions. So that is done in other jurisdictions.
Yeah, so I mean, it's work, but I mean, it isn't enormous work. And if it was the same information and it was just either a question of transposing it or a question, that would be less of a problem to me than somebody having to do 3 different forms that were similar but different, and so the work level is higher. Maybe there are things that can be done in the administration that can keep the burden low, even in the context where there's multiple forms.
That's right.
I wonder if there's places where the ethics office says you can use information submitted to another government entity that has been sworn to and provided within the last year, so that you don't have to, if you did it based on April, do you need to do it again based on October when somebody else asks, or are there places where you can use the April data in order to have the data but not have to reinvent the wheel? And you're going to have to do it again in the next year, so you're going to capture whatever it is on that date. Anything that look like that out there?
Not in any major jurisdiction, but it's possible, and it's something worth researching and trying to determine if that's a better way to do it.
Okay, and I don't want to bang the athletics drum. I mean, the DCSAA, I think, is a sensational entity, but it could surprise people. The DCSAA, I think, entered into a contract with a company about the coverage of championship games, and that it's an exclusive contract. And I do think people might want to be assured that the folks who made that decision didn't have any stake in that. I am 110% sure that they did not, but where there are things like that, do you want to have the kind of disclosure so that you can be sure that there is no conflict? That's the benefit that we get. So with that, I think I will leave it. Again, I'm stuck with, there may be places it's appropriate, there may be ways that you can minimize the burden, but how do we get the maximum benefit with the lowest burden in this setting? I think it's an open question, and I think there can be some creativity. Thank you.
Thank you, Councilmember. I don't have any other questions for you, either of you. Thank you for your testimony. I have your statements. That's very helpful. That's actually a message to witnesses at subsequent hearings. It's always helpful to have the statements. So we'll turn now to Norma Hutchison, who's Chair of the Board of Ethics and Government Accountability, and Ashley Cooks, who's the Director of Government Accountability at the DC Board of Ethics and Government Accountability. When you're ready, I assume Ms. Hutchison, you'll go first. Make sure your microphone's on. It's on.
Good morning, Chairman Mendelson and members of the Committee of the Whole. Thank you for this opportunity to speak today. I am Norma Hutchison, Chair of the Board of Ethics and Government Accountability, known as BEGA. I'm here today to register my concern about the potential impact of the proposed legislation before the Council, Bill 26-325, the Board of Ethics and Government Accountability Clarification Amendment Act of 2025. This bill would remove BEGA's authority to designate additional district employees as public officials who are required to file public financial disclosure statements. Public service is a public trust. This is a bedrock principle that applies to every public official and appointee of the District of Columbia government. When the council established BEGA, it recognized that disclosure is the foundation of an effective ethics regime. The financial disclosure system seeks to prevent conflicts of interest by providing the information necessary to assess whether an individual holds financial interests that may be impacted by the performance of their duties for the district government. With information on a public official's assets, income, and liabilities, the public is able to identify and assess potential or actual conflicts of interest between an individual's work for the district and their personal financial interests. While the Ethics Act defines certain public officials that are required to file a public financial disclosure statement, the council recognized the importance of not keeping this list static and provided BEGA with the authority to designate additional individuals whose duties may create a conflict of interest or appearance of a conflict as public officials. BEGA's 2024 rulemaking designating members of over 40 boards and commissions as public officials required to file public financial disclosure statements was not undertaken lightly. Instead, it was the result of an extensive rulemaking process that took place over several months and incorporated lessons learned after over a decade of BEGA's administration of the district's financial disclosure program. To the extent the council has concerns about whether any specific boards or commissions meet the requirements for filing public financial disclosure reports, we welcome the opportunity to discuss these concerns in more detail. Removing BEGA's authority to designate additional categories of individuals as public officials, however, risked creating the impression that the district does not take ethics seriously and could undermine the public's trust in the operations of the district government and in the public officials engaged in the conscientious performance of their duties for the district government. Thank you, Chairman Mendelson and members of the Committee of the Whole for providing me with the opportunity to testify this morning.
Thank you, Ms. Hutchison. Ms. Cooks?
Good morning, Chair. Good morning, Chairman Mendelson, council members, and members of the public. I'm Ashley Cooks, Director of the Office of Government Ethics for the Board of Ethics and Government Accountability, also referred to as BEGA. I'm here to express the agency's position on B 26-0325, Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025, which repeals BEGA's ability to designate employees as financial disclosure statement filers. BEGA opposes this legislation because it harms the district by removing an ethical safeguard against financial conflicts of interest. BEGA's mission is to administer and enforce the ethics and transparency rules within the district government. Financial disclosure is necessary to ensure ethical compliance and transparency, thereby promoting the public's trust in the district government. As the district's ethics authority, BEGA is exclusively charged with administering the district government's financial disclosure statement program. According to the Ethics Act, employees who make decisions or participate substantially in areas of contracting, procurement, administration of grants or subsidies, developing policies, land use planning, inspecting, licensing, regulating, or auditing, or act in areas of responsibility that may create a conflict of interest or the appearance of a conflict of interest shall file a financial disclosure statement with BEGA. The statute allows BEGA to designate employees who engage in these types of duties as financial disclosure statement filers. The purpose of financial disclosure is to avoid any potential or actual conflicts of interest between employees' personal financial interests and the interests of the district. In December 2023, we discovered that certain board and commission members who meet the statutory definition of a financial disclosure statement filer had not been designated to do so. Because district government boards are created all the time, and we had not designated any entities since our inception in 2012, we felt that it was appropriate time to review the existing boards and commissions. BEGA began researching the district's boards and commissions by reviewing the complete list of boards, commissions, panels, councils, working groups, and committees, including enabling statutes and relevant legislation. We discovered that there were several boards and commissions who were not subject to the financial disclosure statement requirement, despite the fact that they engaged in conduct that warranted safeguarding against financial conflicts. In 2024, BEGA issued a notice of proposed rulemaking, which designated members of 47 boards and commissions as public financial disclosure statement filers. We held 2 30-day comment periods and sent notice to each agency, the mayor, and the council. During that time, we did not receive any negative comments concerning the rulemaking, but on the contrary, the Department of Licensing and Consumer Protection requested that 5 of their presiding boards be added to the list. We designated those entities based on their mission and the duties of its members. The boards and commissions that we identified participate substantially in areas of policymaking, licensing, regulating, or have authority over district government funds. BEGA's rulemaking was a step to fill a gap in the law, but this proposed legislation is an extreme response to our corrective action. Financial disclosure requirements are not uncommon for boards and commissions among other jurisdictions. Members of boards or commissions that are listed in DC Official Code Section 1-532.01E are statutorily required to file. Prince George's County Code of Ethics requires all volunteer members of county boards and commissions to file annual public disclosure statements. Pursuant to Baltimore City Code, any uncompensated appointee can be designated to file a financial disclosure statement. Pursuant to Virginia's code, any person occupying office or positions of trust or employment in state government, including members of governing bodies or authorities, can be designated to file a financial disclosure statement. Financial disclosure is an important tool to maintain transparency in the government. The financial disclosure promotes public trust in district government by ensuring transparency in public officials' financial interests. The goal is to screen potential conflicts so that we can avoid them before they become actual conflicts or otherwise harm the public's trust. The district's 15-question financial disclosure statement contains a thorough cross-section of financial interest inquiry and is not intended to overburden filers. Regarding any privacy concerns or harm to filers' financial interests, BEGA's regulations give filers the opportunity to request all or a portion of their form be withheld from publication. In establishing BEGA, the council determined that the creation of an independent agency with enforcement authority over the comprehensive code of conduct will promote a culture of high ethical standards in district government in an effort to restore the public's trust in its government after misconduct allegations involving multiple public officials. BEGA was created as a means of improving ethics and transparency within the district government. Since 2012, the agency has fulfilled its mission and met its goals by educating and advising employees on the ethics rules, holding ethics rule violators accountable, managing the collection of roughly 9,000 statements on an annual basis, and regulating lobbyist activity within the district. As subject matter experts, BEGA is in the best position to identify whether an employee or public official should file a financial disclosure statement. However, this bill impedes BEGA's ability to properly administer the ethics rules and the financial disclosure statement program, which will cause the district to fall below the national standard. The bill also puts employees and public officials at risk of violating the ethics rules or giving the appearance of such a violation. I ask that the council not pass Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025, as doing so will harm the district government. Thank you for this opportunity to testify.
Thank you, Ms. Cook. So I guess we'll do probably a couple 10-minute rounds. And we'll start with me. Let me see, Ms. Cooks, you said that Vega collects roughly 9,000 disclosure statements
Correct. On
And
an
that's
annual
every May.
basis.
every May. And how many of them do you screen?
We currently screen a sample set of those, and that is because we are understaffed. We only have one auditor. Vega was created and it was underfunded since it was created, so we do not have the audit staff to screen
Okay,
all
so
of
how
the
many-
statements.
So how many do you screen?
We screen about roughly, it has to be within maybe 100, 200. And that's not including the council's biannual statements. That's a different audit that we do.
Yeah, but that's 13 members who file in November.
Correct.
That's a
And in
total
May.
of 13.
Yes.
So of the 100 to 200, how many of them has Vega in a year gone back and said, hey, there's a conflict?
So when we screen them, we look at outside employment. We look at any conflicts with their maybe outside employment that the member has, whether they serve on any board or commission, and that's also available to their spouse. So their spouse's employment. Out of the statements that we've screened, we have opened about, I would say about 70% of those have been under investigation. 70% of the applicants of the statements that we've screened. Of those 70% that have gone under a preliminary investigation, we have found that many of them do engage in outside employment. However, some of that outside employment, there has not been a conflict with their district government employment. What comes to mind when I talk about board and commission members is we've had a few cases that have involved the board and commission members that resulted in a conflict of interest that actually resulted in a fine. For example, we had a case back in 2022 where a board member on the DC Housing Authority engaged in a financial conflict of interest with the company and a person that he was affiliated with, and that resulted in a $15,000 fine.
And how did that case originate?
We received a complaint.
Okay, so it didn't originate from the screening process. So your testimony is that roughly 70% warrant investigation. So that means if you had the auditors, you would be investigating 6,300. That would be 70% of 9,000. Are questionable in terms of questionable activity?
Well, that's if they have anything that indicates a conflict of interest
Okay,
or,
you said that of the
they engage.
100 to 200 that
yes,
you screen,
Yes.
70% warrant further investigation.
correct.
Okay, so 70% of 9,000 would be 6,300 would warrant further investigation. There are that many instances where there is the appearance of something that might be unethical?
There are that many instances where it warrants us taking a further look at a person's financial interest.
And of them, how many actually result in a finding that there was a conflict?
Very smaller subset where we actually find
Like
a
what?
violation
No,
of the
I didn't ask
ethics
about
rules.
fine. I said
Where we make a finding.
a finding of a violation.
It's a smaller number out of
Like
the ones that
1%, 5%? You said very small, so I assume that's single digit.
maybe under 10%.
But you don't know the number. So to get more specific to the rulemaking that was at issue with the council. Explain to me, first of all, you, in your testimony, you suggest that there are new boards and commissions formed all the time, and therefore the implication is that or the inference to the listener is that, well, you found 47 new boards and commissions and added them to the list. I think very few of these are actually newer than 2012. The Board of Industrial Trades has been around for decades. Just as an example, Board of Massage Therapy since the 1990s, Retirement Board since 1974, and so forth. So I guess I don't quite appreciate that implication that was given. But explain to me what the thinking was to add the Metropolitan Washington Council of Governments for disclosure?
So I'll clarify, the rulemaking wasn't just based on new boards that were created.
But that was in your testimony.
Yeah, newly created boards are created all the time, but our rulemaking was based on the totality of the number of boards, not just new boards. So many of the boards that we designated, as you stated, they have been created quite some time, even prior to BEGA becoming in
And
existence.
presumably in 2012, when the initial list was made, these boards were not included for a deliberate reason. But my question was, explain to me the thinking of having the Metropolitan Washington Council of Governments added to this.
So we designated boards based on their duties, not necessarily the members. So if the duties met one of the statutory requirements, then that board was designated.
Like what duties?
Whether they engaged in regulating, policymaking, licensing.
Can you explain what policymaking I assume when you say policymaking, you mean like in the government sense of adopting a policy like 16-year-olds can drive or 21-year-olds can drink. That's a policy. I assume you mean a policy like that, not a resolution that we like apple pie. So just help me here with the Metropolitan Washington Council of Governments. What policymaking do they do?
So it would be policy making that affects the district residents, not whether you like to eat apple pie. Policy
Tell me what
making.
policy making the Metropolitan Washington Council of Governments does that has the effect of law or regulation or spending district money.
The COG is responsible for, let's see.
Well, then let me ask you, why didn't you look at what the individuals do? So
Because
for
the-
example, I sit on the board of the Metropolitan Washington Council of Governments. I sit on their board. I can't remember if I'm an officer. I have been in the past. I'm kind of unaware of what I do that is binding district residents or affecting district residents, other than maybe voting on what the dues are. So just help me here. But beside that, Councilmember Henderson's over there. I can't remember if Councilmember Fruman is. We already filed disclosure statements. So why are we being asked to file disclosure statements a second time?
No, you
What
would
was
always
the
file one
thinking
statement.
behind adding COG to this?
Again, it's based on whether the board or commission meets the definition
No, I
of a
heard that.
public official.
I heard that. You're not responding to my questions, which are, you're not telling me what the policies are that are like of the same sort as other boards and commissions. You're also not telling me why members who are already filing disclosures would be added here to file disclosures again. How about, well, sort of in the same vein, the retirement board, except they actually do important stuff. Why would you add them?
The retirement board has jurisdiction and authority over millions of dollars of district government funds.
Correct, but they already filed disclosure statements.
They file a disclosure statement that is reported to the council. However, BEGA is the district's financial disclosure statement administrator. So they should file with us so that
So
all
why
statements
can't-
are in one centralized
But this
location.
would be a second filing. Why not do a more nuanced rulemaking that would say, all right, retirement board, you need to submit to us your disclosure statements, instead of requiring everybody to do it a second time and to answer questions that may not be really relevant to.
That is what the rulemaking states. It states that DC retirement board should file with BEGA. The retirement board's filing requirement, their statute was made years before BEGA statute. So once the council created BEGA, We took authority over financial disclosure, therefore, they should be filing with us.
Okay, so they should file twice. Either I'm not understanding you or you're not answering me.
Well, maybe the council should amend their statute to require them to file with us instead of filing a different statement somewhere else that nobody even knows exists.
It's a little something. Councilmember Henderson.
Thank you, Mr. Chairman. Director, I want to say I appreciate the opportunity to chat with you. I did bring up COG in our meeting because that part was a little confusing to me. And like I said before, I feel like for some of the boards that are listed in terms of what were added, I can understand, but maybe there just needs to be some clarifying pieces. So one question I would have is that for these new boards and commissions that you all had wanted to add to the financial disclosure system, would they be filling out the same financial disclosure form that say I fill out?
Yes, it's the same 15-question form.
Okay. Are the same 15 questions necessary though for some of the positions where it's voluntary in nature?
Yes, it is. And again, it's based on the duties and authority of that actual board. So for example, the questions ask whether you have any type of outside employment, ask about your spouse's employment, whether you serve in a fiduciary role for a different entity, whether there's a property interest. So those are the types of things and questions that target whether there's an actual conflict of interest. So
Okay.
yes, the same 15 standard questions would apply.
Does MODA ever, the Mayor's Office of Talent and Appointments, have they reached out to BEGA to consult on the conflict of interest questions that they ask prior to someone being nominated?
We have on occasion consulted with MODA when there is reason to believe that there may be a conflict with one of the appointees.
Okay. What I'm suggesting is that to the point that the chairman was talking about around efficiencies, even with the number of professional licensing boards that we have under the health committee, we do have a pretty tough time trying to find individuals who want to serve because it is a very time intensive thing. Financial disclosure on its face may not be an impediment to someone, but it is an additional thing that you have to do on top of something that somebody might feel like, I just did this through my confirmation process. Why can't it be synced, if that makes sense, right? If I am being nominated through the mayor's office, why am I asked to fill out their form as opposed to just filling out the BEGA form, for instance? Did you all consider streamlining where these already exist?
So one thing is that once a person is confirmed and appointed to a board, and they serve in that capacity for 30 days, that's when, and they meet the definition, that's when the financial disclosure requirement attaches. So while they may have provided information about their financial interests prior to them being appointed, our statement asks for financial interests after appointment, which would usually be the prior year. So while MODA captures information before the filing, we capture information, before the designation, before they're appointed to a board, we capture actually that financial information after they become a board member. So it's different information that's being reported on.
Okay. In sort of the back and forth, there, like I said, there's some that make sense and then there's some with question marks. So I'm going to ask about the question like the Interagency Council on Homelessness. Can you elaborate in terms of why you would include those individuals? Considering, I know what it says the Interagency Council on Homelessness is supposed to do, but the actual function within the government, it is not a independent policy-making entity.
So when we did the research for the board and commissions, we did look at what the actual, we looked at what the board or commission stated that they engaged in. And based on that, we found that Interagency Council on Homelessness engaged in policymaking for homelessness.
Did you speak with the deputy mayor for Health and Human Services office that oversees the interagency?
We did not, but we spoke with MODA and they did not object.
Ask the same question on the health ones. Did you have a conversation with anyone at DC Health that administers all of the health professional boards?
We reached out to the DC Health Ethics Counselor. We had a conversation with that person within that 60-day public notice period. And they did not express any concern or negative feedback for the designation of those boards.
Okay. I'm also wondering, because there are some boards that you have on the list that the time that you all were doing rulemaking, the commission was essentially defunct. There were no members and it hadn't met in 2 to 3 years. So I'm trying to determine whether or not there were conversations made before we were just sort of going through the code, looking at what boards and commissions exist, looking at what it says statutorily as opposed to what it is today.
So we found that out later after the rulemaking was finalized. During those conversations, that did not come up, that some of those commissions were actually debunked and that some of them would be removed, repealed. So we didn't have that information when we were reaching out to agencies and when we had filed the public notice.
Okay. So I said I have oversight over 23 of the 47. Are you aware of incidents in the past 10 years in which a member of a board or commission that makes decisions about awarding or revoking licenses has been found to use their authority improperly?
Yes, there's a case that's actually a criminal matter going on right now with a member of the Board of Cosmetology having allegedly given licenses to individuals for pay. So a potential bribery case that is up for criminal prosecution at this time.
Okay, but the conflict of interest form wouldn't have necessarily uncovered that particular type of situation.
Well, there is a gifts question, but again, that's if the person discloses it. They're certifying that the information on the form is accurate and truthful under penalty of perjury. So that question could have potentially caught it. And that individual also has some outside interests in a beauty school and a possible, a beauty school that would have been flagged on their financial disclosure statement.
Okay. Yes, I'm sort of, like I said, I do think that there are some questions that should certainly be asked. There are questions that we ask when we go through the vetting process to ensure that folks that we are confirming don't have financial interest in a variety of other entities, that they could be improperly influenced in terms of their role on the board. It sounds as though, at least from the public witnesses who testified, and then of course for some of the council members who have expressed support for this particular legislation, that they are concerned about the process. Director, is there anything that you all would have done differently in terms of the rulemaking process to improve, I don't know, knowledge or transparency about what you were trying to do? I know hindsight's 20/20, but I'm going to ask that question. Is there anything you would do differently?
We have 2 30-day comment periods. I guess differently is that we could have made a little more noise about it. More than what we had, more than what we did. We thought that it was sufficient to hold the 2 comment periods. We had gotten comments from the mayor's office. We got a few comments from other folks, but none of them that would have triggered that this would have been an issue, designating these folks.
Are there any boards that were included, boards or commissions that were included in your original list that now with further information you would amend off?
I guess the COG, since that has brought up such an issue.
Well, and you're sort of joking about it, but you know, members of the COG doesn't just include DC. It does include other jurisdictions, and at least as far as I know, all of the members of the COG from DC are all elected officials who would be filing anyway. So there's that. But I think for some of the other ones, did you all publish any documentation to say like, this is why we feel like, so for instance, let's pick one. The Health Education Licensure Commission. Did you all provide information in terms of why you feel like this commission needs to be added or meet the requirements under?
We didn't provide any information outside of that we felt they met the definition of the statute, as well as the information that we provided when we spoke to the ethics counselor. So nothing outside of that.
Okay. Do you feel like the definition of the definition of a public official is too broad?
If policymaking is a concern, then yes, that would be a fix to remove that from the definition of public official rather than striking the agency's authority to designate. Or as an alternative, which one of the public witnesses brought up was that maybe give the agency the authority to designate confidentially as well. It doesn't solve public transparency, but at least someone would be looking at these statements. We could possibly audit those statements to ensure that there are no financial conflicts of interest.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. Councilmember Fruman.
Thank you very much, Chairman Mendelson. As I'm listening, I hear kind of three layers to this discussion. One is the legislation itself, which is severe, takes away the authority. And so that's one kind of question. Is that the right remedy here to completely take away the authority? I'm just going to put a pin in that, but note that it's a severe remedy. Another is, are the agencies that are on the list, are they appropriate, or are there changes that might be made? On the COG, I'm hearing the back and forth, and I serve on the Transportation Planning Board. The fact that it's elected officials or government officials who serve on it and they already are doing disclosure is important to me. But the COG, the thing I associate with the COG recently is a decision to have the three jurisdictions work together to fund WMATA and spend hundreds of millions of dollars. And so it's a big institution of consequence. So I can see why you would say it should be regulated, but I also can understand the idea that folks are already elected officials. And the Transportation Planning Board thing we voted on was whether or not there should be toll lanes over the Wilson Bridge. Billions of dollars at issue and contractors involved. Should there be disclosure? I think there is disclosure for me on that because I already am doing your exact form in another setting. So you have that, but would you want disclosure there? I think maybe you probably do. So I don't want to go through everything on the list, but I think it is worthwhile to go through things on the list. I feel a little sympathy for you on process. I see Anthony Hood over in the corner, who's the chair of the zoning commission, and he hears at every hearing, I never heard about this. Like, this happened and I got no notice. And then it turns out there was a process with 2 rounds, 30-day rounds of comments. Like, you could feel like we didn't do this in the dark of night. We did this through in a process, but then when it becomes real, then you get a reaction. But that's the world we live in. That's where we are, is whether you would fix your process, do something different now, open question. If you banged more pots and pans together, would people have paid more attention before? And instead of waiting until now, here we are, people are paying attention. It's still worth doing the scrutiny in this moment. And then the third layer is administrative stuff. And I was asking questions about this in the last round, and so I want to go back to that. One of the people said, you got a guy who's been on a board for 10 years, and the board wasn't on the list. And if I understood his testimony correctly, the board wasn't on your first list, but maybe DLCP said, you should probably have that board on your list, and you put it on the list. And now you got somebody who's been there for 10 years, and they not only have an obligation to do a filing next year, but are they supposed to do a filing going back 10 years? Is it retroactive?
No, the filing is for the previous calendar year. So if anyone who serves on a board or commission for 30 days in that previous calendar year has to file financial disclosure for that period. not, it doesn't go back as far as 10 years or when the person was first appointed.
But it goes back. I mean, I do wonder whether or not it would be better if you have a new obligation and that applies to the coming calendar year, and you can have a decision about whether or not you want to participate based on this thing that is a new obligation that didn't exist at the time that you first signed up. Just food for thought on that. I also hear you that you developed your form, you have your 15 questions, they're very thought through. The idea is this gets at what a person has an interest in, and you don't want to rely on a form that somebody else may have created somewhere else. To what extent do you try to work with agencies that are doing their own financial disclosure to make sure that they ask your 15 questions?
So we don't actually work with agencies so they can implement our 15 questions. What we ask agencies to do is to designate employees so that they can file our form.
So would you go to the place that's asking for disclosures, that they're doing their own disclosure, and say, we don't want people to have to do it twice, but they should do our form and get that form so that people don't have to do it twice? How do we avoid the issue of doubling the burden?
I'm not aware of any agency that requires a financial disclosure statement of their employees. They usually designate them to file with us either publicly or confidential.
Yeah, I mean, I'm forgetting, but I thought we had testimony earlier today about that happening.
That MOTA asks certain questions before they offer someone to the council. That's the only other requirement that I'm aware of.
I'll come back to you, but my impression was there were different boards where they were doing a round of disclosure and yours added to it.
You mean DCRB, since they're already
Yeah,
statutorily required to file financial disclosure statements.
that could be the one that came up. So can we harmonize that? Is there any effort that instead of DCRB doing its own disclosure, that they use yours so that the people don't have to do it twice? Has there been any effort to do outreach around that?
We did have a conversation with DCRB, of course, after the rulemaking was finalized, and they expressed the concern, same thing, that they're already filers. That we looked at their form, and their form is a bit different from ours. So we encouraged them to file with us and maybe get the council to amend their statute, which would only require one filing.
Okay, so it strikes me, I'll tell you where I sit. I don't want to strip you of authority. So I don't like the legislation as it sits. I am uncomfortable with the list, given all of the different questions, and would love to see a process where that got rethought. And I also see these administrative issues and clarity around these administrative issues as something that could be sorted out. Now, you could feel like, we did this rulemaking process, we had 30-day comments, like we did this, but there's enough static here that a revisiting strikes me as a constructive step, as a way to get to something that people can feel more comfortable with without taking an action that strips authority from you, which in the biggest picture sense, it would be the government of the District of Columbia saying, we not letting an independent agency that we charged with doing oversight on ethics make decisions about ethics. My preference is not to be there, but it doesn't mean that where we are should be where we end. I'm hoping there's something that can be done that lands the plane in a way that feels fair to everybody.
Yeah, we're open to since there is so much concern about the rulemaking, we're open to having further discussion about those entities that were designated. But as you stated, with this legislation, that is not even possible.
All right, with that, I'll leave 50 seconds on the table. Thank you.
Thank you, Councilmember Fruman. Thank you for your generosity too with the minutes. I missed something that you said about amending the law. This was just a moment ago. You said to Councilmember Fruman about maybe the council amending the law to require only one filing.
Correct, for
What were you-
DCRB.
You would have would be your filing.
Correct.
Even though, and I haven't looked at the retirement board filing, but I'm reasonably certain that it's much more specific to what the retirement board does and probably consistent with filings required, filings required for similar retirement boards in other jurisdictions. In other words, not the standard 15 questions you ask, but a very different and more specific and relevant set of questions.
I've looked at the form and the form is similar to ours. It's not quite the same. I wouldn't say that theirs is more specific because they both forms try to gauge financial interest from a person's employment, their spouse, property, stock. But it's our opinion that since we are charged with financial disclosure, that they should be filing our form and have it stored in a centralized location.
So I'm going to go back to the cosmetology example that you gave. So the individual who's being prosecuted is or was, did that individual disclose their outside business?
I don't have the form with me, so I'm not sure. But if
Okay.
they should have, basically, because
I
they are.
understand they should have, but I'm also remembering, I think it was Ms. Hutchison's testimony that used the word prevent. In your testimony, Ms. Cooks used the language several times, ensure compliance with the law, prevent conflicts of interest. So I'm not, if they did disclose the outside business, it seems to me it didn't actually prevent their violating the law.
Well, it didn't prevent them from taking bribes, no, but
Correct.
it would have flagged, at least been a red flag for us to take a further look into that statement.
Of an outside business. Is that a red flag? I get that that might be something to look at, but is that necessarily a red flag? So as chair, I'm prevented from having outside employment, but all the other council members can have outside employment. If they do, is that a red flag?
It could be. It depends on what the outside employment is.
I'm not quite sure how to respond. I mean, I sort of feel like this is chasing a problem without being very clear about it. Yes, it's conceivable, theoretical, that if a council member has an outside business activity, that there could be some wrongdoing. Theoretically conceivable. Probably, if I thought long and hard, probably has happened, if not here, then elsewhere. But it doesn't mean that every member who's had an outside business activity did something criminal or unethical. So I would hardly call that a red flag, which is what you're calling it, or warranting additional investigation. So why the same 15 questions for every individual? I'm thinking, for example, the Interstate Commission on the Potomac River Basin.
Can you repeat the question?
Why the same, exact same 15 questions, which is actually closer to 30 since it includes spouses, to every individual regardless of what the border commission is? For example, the Interstate Commission on the Potomac River Basin.
Again, the same 15 questions are solicited from everyone to gauge whether there is a conflict of interest. And it's actually 15, it's not 30. The 15 captures the spouse's financial interest as well.
My bad, you're right. The Interstate Commission on the Potomac River Basin is advisory. So I don't know why they would be included. I would guess that you're going to say that you looked and they have some involvement with policy. I have not a clue what that policy is. But I'm really hard pressed to understand why they're owning stock in some company is relevant to understanding whether there's a conflict of interest for their position. I could say the same about the Interagency Council on Homelessness. They're not doing procurements.
So if a person owns stock in a particular company, that company is by definition a person closely affiliated with that entity, with that person. Therefore, they are prohibited from having any involvement with any matters that involve that company. This does not include stock investments that are handled by a third party. This is.
You're giving me a very general answer. I'm bringing it back to a specific board because that's what we're talking about here.
Which board?
The Interstate Commission on the Potomac River Basin. I could say the same with regard to the District of Columbia State Athletics Commission. And there was comment earlier by you or somebody about how they procured something. That actually was not the commission, that would have been the staff. And they're not at issue here.
I think that was Councilmember Henderson's comment about procurement from that board.
All right, I'm just clarifying that I'm not quite getting why stock holdings are relevant to participation on the District of Columbia State Athletics Commission or the Interstate Commission on the Potomac River Basin or the Metropolitan Washington Council of Governments. I'm not even sure with regard to the health commissions, but I won't go there because that's the Committee on Health. I guess my reaction to this is that it's like one size fits all when it's not one size fits all. Some of these boards and commissions, no, every one of these boards and commissions is unique relative to the others. And the duties are quite different from one board to the next commission, but that seems to have not been relevant at all to the rulemaking.
So again, we're open to adjusting our rulemaking, but this legislation does not allow us to do that.
At this time, I don't have any other questions for you. Thank you all very much.
Thank you.
I forgot to note this at the beginning, but the record in this matter will be open for 2 weeks. Anyone who wishes to submit any additional statements or information, and when I say anyone, that includes folks who did not testify, the record will close at 5 p.m. on Tuesday, January 27th, 2026. We have another hearing to follow, which we will start at 1:05. The time right now is 1 o'clock and this hearing's adjourned.
That part. Guys don't need your edit. He said we're good. Yeah, he said we're good, so.
I'm calling to order this public hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council, Chair of the Committee of the Whole. Today is Tuesday, January 13th, 2026. The time is 1:09 in the afternoon. We are having this hearing in room 412 of the Johnny Wilson Building. I do want to apologize to folks who were here to testify regarding these bills that we're starting later than we had originally thought because we had a hearing before this that went on longer than we thought it would. This hearing is the second of three hearings the Committee of the Whole is having today, and this hearing concerns, I believe, 13 pieces of legislation. Maybe somebody can count. I'll read the titles, but I'm not going to describe them, I don't think. Bill 26-371, closing of a portion of a public alley and establishment of a building restriction line in Square 2319, which I believe is in the area of Utah and Nebraska Avenue. Bill 26-308, the Jules Way Designation Act of 2025. Bill 26-330, Greens Court Park Designation Act of 2025. Bill 26-331, Harmony Park Designation Act of 2025. Bill 26-365, Lenora Baker Way Designation Act of 2025. Bill 26-415, Joseph Bowser Way Designation Act of 2025. Bill 26-431, Rodney Wright Basketball Court Designation Act of 2025. Bill 26-432, Roland Fatty Taylor Way Designation Act of 2025. Bill 26-435, Malachi Jackson Way Designation Act of 2025. Bill 26-437, Stronghold Way Designation Act of 2025. Bill 26-533, San Romero Plaza Designation Act of 2025. Bill 26-534, Charlie McCormick Way Designation Act of 2025. Bill 26-550, Ralph Bunch Way Designation Act of 2025. And Bill 26-551, Union Wesley Way Designation Act of 2025. Most of these bills are what we call ceremonial designations or symbolic designations. And a symbolic designation is not an official name and is subordinate to an official name. I'm not quite sure at the moment. I don't remember if any of them are official. The alley closing is a little bit different. That's the first measure. And that would close a portion of a public alley system in a square bounded by Utah, Rittenhouse, 28th Street, and Nebraska Avenue Northwest in Ward 4. We will, as we get to each bill, I'll say a little bit more about them, whether it's, if it's official, I'll note that as well. So we have two witnesses for the first bill. The order in which I read the bills is the order in which we'll take them up. The first bill is Bill 26-371, closing of a portion of a public alley and establishment of a building restriction line in Square 2319 SO 22-02364, Act of 2025. And the two witnesses I have are Mark Lagana, who's surveyor at Department of Buildings, and Brant Miller, who's manager of policy and legislative affairs, District Department of Transportation. This bill was introduced by Councilmember Louis George on Monday, September 29th of 2025. And the stated purpose is to order the closing of a portion of a public alley in that square. Mr. Lagana? I don't think we've seen you before.
No, we haven't. Happy New Year.
Mr. Miller, who's sitting to your left, will tell you how horrible this inexperience this will be for you. So when you're ready, please proceed.
Okay. Good morning, Chairman Mendelson, council members, and staff of the committee. of the Whole. I am Mark Lagana, Surveyor of the District of Columbia at the Department of Buildings. I appear before you today to provide background information on Bill 26-371, closing of a portion of a public alley and establishment of a building restriction line in Square 2319, Survey Order 2202-364, Act of 2025. This bill was introduced by Councilmember Louis George. The purpose of this bill is to order the closing of a portion of the public alley system in Square 2319, bounded by Utah Avenue Northwest to the west, Rittenhouse Street Northwest to the north, 28th Street Northwest to the east, and Nebraska Avenue Northwest to the south in Ward Ford. According to the property owner, the proposed closing would enable the beautification of the closed portion of the public alley, which abuts portion of the land formerly owned by the Episcopal Church for the Children that was recently purchased by the Moret School and would also clarify the title to the land. The applicant for this bill is Joshua Kern, who is represented by Sullivan and Barrows LLP. The Office of the Surveyor notified the relevant executive branch agencies of this application on July 26 of 2023. They offer no objections. The utility companies were notified of the application on July 26 of 2023. They offer no objections. Pursuant to DC Official Code Section 9-202-02-3, the Surveyor's Office notified the National Capital Planning Commission of this application on July 26, 2023. In a letter dated June 29th of 2022, NCPC, which is the National Capital Planning Commission, determined that upon review of the project documents, National Capital Planning Commission staff determined that the proposed project falls under an exception listed in Chapter 8 under NCPC submission guidelines. Pursuant to DC Official Code, Section 9-202-02-5, Advisory Neighborhood Commission 3-4G was notified of this application July 26 of 2023. And a letter dated May 3rd of 2024, ANC 3-4 supports this application. In conclusion, this concludes my testimony. I appreciate the opportunity to appear before you today and welcome your questions that you may have regarding this matter. Thank you.
So before I go to Mr. Miller, so you're newly appointed as the surveyor,
I'm newly hired, yes.
newly hired.
Yes,
Excited so far?
I am. It's only been a week and a half.
It's an office with a lot of history
It does.
and so welcome.
Thank you.
In your testimony near the bottom of page 2, you said in a letter dated June 29th, 2022, NCPC determined, but they were notified on July 26, 2023. Are those, it's possible, but can you double check those dates?
In a letter dated June 29th, 2022, National Capital Planning Commission determined that upon
Yeah.
review of the project,
But if you look at the paragraph above, it says you notified NCPC on July 26, 2023. It's possible, but if you could just check that and let us know.
before that, it says the executive branch agencies were notified on those dates. July 26th of 2023.
End of that paragraph.
Pursuant to DC Official Code, the DC Surveyor's Office notified National Capital Planning Commission of this application on July 26th of 2023.
2023. That's a year after NCPC determined. If you could just double check the date.
Okay.
Mr. Miller?
Yes, good morning or good afternoon. This is actually a portion of a combined testimony, so forgive me if there's some awkwardness as I try to parse this one out. Good morning, Chairman Mendelson, members of the council, staff, and district residents. My name is Brant Miller, Manager of Policy and Legislative Affairs at the District Department of Transportation, commonly referred to as DDOT. I am here today to present testimony on behalf of Mayor Muriel Bowser and DDOT Director Sharon Kirschbaum regarding Bill 26371, the closing of a portion of a public alley and establishment of a building restriction line in Square 2319, Surveyor's Order 2202364, Act of 2025. The stated purpose of Bill 26371 is to close a public alley at 5931 Utah Avenue Northwest and establish a restriction line in Square 2319, Surveyor's Order 2202364. After the amendment to the original proposal, DDOT supports the closure and building restriction line establishment as outlined in the Surveyor's Order report filed by DDOT with the DC Surveyor on August 29th, 2023. Thank you so much.
And what did all that say? So what was the amendment to the original proposal? Do you know?
Yes, there was originally a piece of the alley that was proposed to be closed that is actually needed for trash truck turnarounds. The new closure proposal does not include that space. So that section of the alley will remain public.
So when I look at the plat, it's the part in red that is not affected. That's
Correct.
the amendment.
Yes.
And so the plat is otherwise okay, and we have a copy of the DDOT report that you refer to?
If you don't, we can provide one.
I think I just heard a yes.
Okay.
In my left ear. All right, give me a second. Well, I think I'm almost done. Can you give me a minute? No, I won't. You're not aware of any objections to this, either DDOT or the surveyor?
No.
Any objections? I do not have any other questions. So thank you. And I guess Mr. Lagana, I don't know if you come back for any of the designations, but Mr. Miller, we'll see you for the rest of them.
Yes.
Let me turn to my colleague, Robert White. He's chairing another hearing right now, so I think you're on a short leash.
I am. Thank you, Chairman. Today, we speak the name of a young man whose life should have stretched far beyond the years he was given, Malachi Jackson. He was full of promise, an athlete, a student, a son, a friend. He was the kind of young person who reminds us why we fight so hard for our city's future. His laughter, his energy, his dreams, they mattered, and they still matter. When a child in our city is taken, the loss doesn't end with a headline. It ripples through classrooms, through families, and through entire neighborhoods. It leaves an empty seat at the dinner table, a silence where there should have been a future. Malachi's family carries that weight every day. They do it with a lot of grace. And yet they have shown extraordinary courage in choosing to honor his life by ensuring his name continues to shine. By designating this street as Malachi Jackson Way, we would do more than place a sign on a pole. We would affirm that Malachi's life had meaning. We are saying to his family, to his peers, and to every young person in this city, we see you, we remember you, and we will not accept a future where our children's lives are cut short. This designation is a tribute, but it is also a call to action, a reminder that our work to build safer, more nurturing city is not abstract. It is urgent, personal, and deeply human. To Malachi's family, thank you for allowing us to honor him in this way. Your strength is a testament to the love that you carry and the legacy he leaves behind. Thank you to Council Members Felder and Nadeau for introducing this bill so that Malachi's name stands as a permanent symbol of hope, remembrance, and our shared responsibility to protect every child in the District of Columbia. Certainly that is what we owe them. And a street with Malachi's name would be a reminder, not just for the family and friends, but to all of us of what we owe the young people in our city and how important their lives are. Thank you, Chairman.
Thank you. And you have this hearing, so you may not be here when we get to that.
I will not be here when we get to it. I have to go back to my hearing that I'm chairing. So thank you,
Okay.
Chairman.
Thank you. So we're going to turn to the next bill, which is 26-308, entitled the Jules Way Designation Act of 2025. And I have 4 witnesses. If they're here in the room, I'm gonna call them all up at the same time. Barbara Beverly Lindsay Johnson, Director of Programming at the African American Music Association. Sandra Bears, Dolores Powers, and Julia Lindsay. Any of those folks here? And I will note while you're coming forward, this bill was introduced by Councilmember Janice Lewis George on June 26th last year. And the purpose of the bill is to symbolically designate 13th Street between Upshur Street and Allison Street in Ward 4 as the Jules Way. Give me just a second. All right, give me a second. I'm assuming Miss Lindsay Johnson is not here. You are Miss Lindsay Johnson. Excellent. Please proceed. Turn your microphone on.
Oh, okay. Good afternoon, Chairman Mendelson and Committee of the Whole. My name is Beverly Lindsay Johnson, and I'm representing the African American Music Association. And the organization requests consideration of a commemorative street sign, the Jules Way, to be placed in front of Roosevelt High School on 13th Street between Allison and Upshur Street Northwest in Ward 4. This special street sign will honor the accomplishments of the 1960s female group, the Jules, who are considered to be DC's doo-wop divas. The original Jules group are all graduates of Roosevelt High School in the early 1960s. The original 4 members are Sandra Bears, Grace Ruffin, Carrie Mingo, and the late Margie Clark. Martha Harvin joined the group later on. And the Jules had various name changes, beginning with the Impalas. Then they became the 4 Jules, and finally the Jules. The young ladies recorded as a professional singing group while still attending Roosevelt High School as teenagers. Later, their hit recording, Opportunity, stayed on the national Billboard charts in 1964 for 12 weeks. The epic of the Jules' career is when the godfather of soul, James Brown, saw their performance at the world-famous Apollo Theater in New York City and requested that they join him on the famous James Brown Review Tour. What started as 6 dates with the Jules became 1 year on tour, over 300 dates with James Brown. The Jules were James Brown's first female background singing group. The Jules have been awarded recognition from previous DC leaders and organizations. They continue to serve Washington, DC. Also, the group are the subject an award PBS documentary, The Jewels, The Divas of DC Doo-Wop. The Jewels are deserving of this commemorative street sign, The Jewels Way, to be placed in front of their beloved Roosevelt High School. Thank you for this opportunity to speak before the council.
Thank you, Ms. Lindsay Johnson. And next we have Sandra Beers.
Yes, good morning.
Wait a minute, hold on.
Okay, good morning. My name is Sandra Peoples Bears. I'm one of the original founding members of the Jules Female Vocal Group. The other members are Grace P. Ruffin, also an original founding member, and the late Margie Clark, Martha Harvin, and Carrie Mingo Owens, all original members from the 1960s. The journey of the Jewels started from Theodore Roosevelt, although Grace and I had been friends since Banneker Junior High School when we were just 13 years old. That's just a few years ago. All of the Jewels graduated from Roosevelt in 1961 and 1962. And as far as I know, the Jewels are the only female vocal group since 1960s from Washington, D.C., who have had the national success of 60 plus years in the music industry. There were several people who were very instrumental in our musical career, starting with the legendary Bo Diddley, who helped us get our first recording released. And he also took us to Chicago, along with Billy Stewart, to record on the famous Chess records, songs like Loaded with Goodies, Johnny Jealousy, and Erasers on Pencils, to name just a few. The Jewels also recorded on Dimension label and King record label. We got our big break when we recorded our national hit Opportunity, which stayed on the national charts, Billboard and Cashbox for 12 weeks in the top 50s. Something else happened to the Jewels while performing at the world-famous Apollo Theater. The Godfather of Soul came to the show, and he was very impressed by the Jewels' standing ovation performance, and he asked us to tour with his show. Places like Madison Square Garden, Miami Stadium, Hollywood Bowl, just to name a few of the venues. The Jewels also had the pleasure of backing him up live on Say It Loud, I'm Black and I'm Proud. It's very hard to put the Jewels plus years into a few words. We have been honored and recognized by several mayors of the District of Columbia, starting with Mayor Marion Barry, Mayor Sharon Pratt Kelly, and Mayor Muriel Bowser. In 2008, the Jewels received the Mayor's Arts Award at the Kennedy Center. The Jewels have always given back to the community in the form of fundraisers, workshops, and women history presentations. The Jewels, along with many other artists, are presently featured in a historical portrait called The Pioneers of Rhythm and Blues, Rock and Roll, and Doo-Wop. This exhibit is currently in the Stromberg Center for Research in Black Culture in New York City, the Smithsonian Anacostia Neighborhood Museum in DC, the Auburn Avenue Research Library in Atlanta, Georgia, and also the Moorland Spingarn Research Center at Howard University. The Jewels' 50-plus years was captured in a documentary produced by Emmy Award-winning producer Beverly Lindsay Johnson, The Jewels, the Doo-Wops, the Divas of Doo-Wop, The Jewels, the Divas of DC Doo-Wop, and was shown at the historical Howard Theater and aired on PBS television station and Howard University television station regularly. I truly appreciate the opportunity to share the Jewels' 60-plus years journey and their contribution in the music industry starting from 1961 at Roosevelt High School to today, 2026. Thank you for your time. Sandra Peoples Bears of the Jewels.
Thank you. Are you Dolores Powers?
Yes.
All right.
Good afternoon, Chairman Mendelson. Thank you for the opportunity to speak at the council hearing of B 26-0308, the Jewels Way Designation Act of 2025. I am Dolores Powers, proud native Washingtonian of 77 and a half years and a proud 1966 graduate of McKinley Tech High School. I know the four jewels of DC, or simply put, the Jewels. Our school dances at Tech's Gymnasium included hand dancing to the Jewels' #1 hit, Opportunity. If you wanted to slow drag with a fellow, just listen to All That's Good. We listened to all the Jewels recordings on WOL and WOOK, WOOK radio stations with disc jockeys Moon Man and Bobby Bennett. We saw the Jewels perform at the historic Howard Theater on numerous occasions with the Temptations, Smokey Robinson and the Miracles, Billy Stewart, and other entertainers of the doo-wop era. They returned to the Howard Theater in 2012 for a documentary that was produced by Beverly Lindsay Johnson about them. The Jewels are DC's girl group, and it is befitting that a street in front of their alma mater, Roosevelt High School, be named the Jewels Way. Thank you.
Thank you, and I'm assuming that I have a lot of paper here. That Julia Lindsay is not here? Julia? Okay. I don't think I have any questions for you. Ms. Bears, it's really nice to meet you. Are you all still performing?
Yes.
Microphone.
Can we sing something?
I said, but turn the microphone on. So you all still performing? Actually, if you perform, you should know about turning microphones on and off.
Sorry. Well, no, we're not still performing right now. Margie passed in 2019. Grace is on dialysis. She goes 3 times a week. Her health is doing pretty good. And Martha is in Holland, and here we are here. I'm
Yeah.
here. Yes.
Well, it's great to meet you. I suspect that will go through with no difficulty at all. Councilmember Felder, do you have any questions?
Thank you, Mr. Chairman. None at the time, but I appreciate the testimonies.
You don't want to ask about if you want to slow drag with a fellow, or just listen. All right. Thank you all very much, and thank you for being here. If you have any questions about the process, just follow up with my office, but we will probably at some point in the next month or two, as you know, there are a lot of these bills here, but in the next month or two, we will move this forward out of committee before the full council. And then once it becomes law, then there's usually some sort of a event to hang the signs, the street signs.
Absolutely.
And usually the member who introduced the bill is in the thick of that event, but we'll
You
see.
mean the Ward 4 council member?
Yeah. In this case, yes.
Yes, she would be.
Okay. Thank you all.
Thank you very much.
So we'll turn to the next bill, which is Bill 26-330, Greens Court Park Designation Act of 2025. This bill was introduced on July 14th by Councilmember Pinto, and it would symbolically designate the playground and dog park at 26 and I Streets Northwest as Greens Court Park. And I have 3 witnesses on the list: John George, Frank Leone, and Will Crane. You are,
I'm John George.
okay. Do you know whether Mr. Leone or Will Crane will be here?
Mr. Leone will be on the Zoom, if that's possible. And
That's possible.
I do not believe Mr. Crane will be.
Okay. So why don't you proceed?
Great, thank you. Good afternoon, all. My name is John George. I'm the president of the Foggy Bottom Association and a 30-year owner resident in Foggy Bottom. Thank you for placing B-26-0330, Greens Court Park Designation Act of 2025 on today's agenda. The Foggy Bottom Association, the FBA, which represents historic Foggy Bottom and the West End, has a legacy of protecting our historic features and recognizing our important past. There have been countless times when our residents have rallied to protect our unique neighborhood. However, we have not always been successful. Our unique alley dwellings of today, specifically Snow's Court and Hughes Mews, give our neighborhood a special charm and a glimpse into the past. Greens Court was also an alley dwelling located between 26th and 27th Street Northwest and I and K Streets Northwest. Sadly, it did not survive urban renewal of the 1960s. Many residents, primarily African American, a school, a church, were displaced, and the area was bulldozed to make way for the Potomac Freeway and the Whitehurst Freeway. We are left with an isolated set of row homes along the 2600 block of I Street Northwest, congested on-ramps and exit ramps from these highways, and a desolate walkway along the south side of K Street Northwest. The genesis of the FBA in the 1950s helped save historic Foggy Bottom and a sliver of green space on the western edge of the 900 block of the 26th Street Northwest. Over the years, the FBA and countless volunteers have tended to this green space as a buffer from the highways. The area now includes a brick plaza for community gatherings, a dog park, and a children's park. Residents, including families with young children and lots of dogs, have enjoyed this respite for decades. Recognizing that these spaces deserve more than a volunteer force, the FBA, along with ANC 2A and our council member, Brooke Pinto, worked tirelessly to secure funding for renovations for these areas and declaration as an official Department of Parks and Rec park. We thank Councilmember Brooke Pinto for securing funding for this renovation in 2021 DC budget. While it took time for the Department of General Services and the Department of Parks and Rec to begin renovation, the community engaged in planning meetings, design reviews, and countless emails to now realize the updated park. In parallel, the Foggy Bottom Association surveyed community members to identify a name for the park. And in 2025, following a review of names and a democratic process, the name Greens Court Park was selected by the community. The name is a fitting tribute to those who have gone before us. We wish to honor and remember those residents and neighborhood that once was. We encourage the members of this committee of the whole to designate the park as Greens Court Park. Thank you.
Thank you, Mr. George. Frank Leone?
Thank you, Mr. Chairman. My name is Frank Leone. I'm a homeowner resident of Foggy Bottom and the co-chair of the Foggy Bottom Association History Project. Also, my beagle and I very much enjoy the park, and so we thank the city for providing it. Now, the FBA History Project has developed an interactive historic district house map that includes the 4-block historic district, but it extends 3 blocks west towards the river to include the area that John was speaking of. It now only holds 3 historic houses, but it once contained a neighborhood of 200 residents, churches, stores, saloons, and an elementary school. And the neighborhood was demolished for the construction of the Potomac Freeway and the Whitehurst Freeway ramps, but it's still important to remember and honor the neighborhood. Square 5, where the park is located, also contained an alley known as Greens Court. That's where we come up with the name. And alleys were, of course, once an important part of DC. In 1890, about 10% of DC's population, typically the poorest, lived in alleys. We're lucky to have 2 alleys remaining in Foggy Bottom, but we were not able to save Greens Court. It was once a thriving community with row houses, small apartment buildings, immigrant-operated grocery stores, saloons, and oyster bars. The brick plaza at the park was the site of the Morning Star Baptist Church from 1920 to 1961. Across 27th Street was the Briggs Montgomery Elementary School. In 1939, the school's PTA tried to convince the DC Alley Dwelling Authority to install public housing in Greens Court. The authority rejected the request, but First Lady Eleanor Roosevelt came to visit on Christmas in 1940. So the Foggy Bottom Historic District has a period of significance of 1860 to 1915, in large part because of the Irish American, German American, Russian American, and other immigrants who migrated to that industrial neighborhood. But the FBA History Project also seeks to bring to life the more recent neighborhood, including the 1920s to the 1950s, when it was a majority African American neighborhood. The city has named the new park that includes a dog park in Noma, Swamp Poodle, to remember the Irish American neighborhood that was there. And likewise, naming Greens Park provides an important reminder of the communities that came before us and the lessons we can learn from their passage. So I thank you for your time. I've submitted written comments that also have a few illustrations. Thank you.
Thank you, Mr. Leon. And I do have a copy of your statement with the photographs. So thank you for that. I do not have any questions. Let me double check. Okay. And this would be an official naming, I believe.
Great. Yes.
Thank you for being here. Your testimony is helpful.
Thank you.
So thank you.
Thank you.
And I didn't call Will Crane because I was told he was not here. The next bill is Bill 26-331, entitled Harmony Park Designation Act of 2025. This legislation was introduced on July 14th last year by Councilmembers Pinto and Nadeau. And the purpose of this legislation is to symbolically designate the Triangle Park between New Jersey Avenue Northwest and Rhode Island Avenue as Harmony Park. I have 4 witnesses. Miguel Tundale Duramo, I believe is online, Chair of ANC 1B. Matt Fay, Secretary of ANC 1B. Alexander Padro, Executive Director at Shaw Main Streets, and Michael Hewling, President, LaDroit Park Civic Association. You are?
Matt Fay, ANC 1B.
Okay.
Mr. Hewling will be unable to attend. He's submitted his remarks online.
Okay. I see Mr. Duramo and Mr. Padro here, so that's a good sign. Why don't we reward you, Mr. Fay, as going first since you're here in person?
No reward necessary, but thank you, Chair. Chair Mendelson and members of the council, thank you for the opportunity to testify today. I'd like to start by thanking council members Pinto and Nadeau for their advocacy and support of the Harmony Park Designation Act. This act provides an opportunity for the council to recognize an important part of DC history and celebrate an important milestone in African American history in the district. I won't spend my time today reviewing that illustrious history in my testimony. Much of those details are included in the act itself, the ANC 1B resolution in support of this act, the letter of support from the LaDroit Park Civic Association, the exceptional online material produced by Shaw Main Streets with a history of the inspiration for this park, and the testimony that you'll likely hear today. However, I do want to take a moment to share what this space has become today and why this is the perfect location to celebrate the ideals of the Colombian Harmony Society and to ensure that they live on within our community. It's not often that the district is able to create brand new green space. When DDOT completed the S Street revitalization project in this past year, it returned to the community land that had previously been used as an urban highway. Today, this triangle of green space sits at the intersection of wards 1, 2, and 5. Parents are teaching their kids to ride their bikes on the car-free pathways. Residents across multiple wards are crossing through the park daily to reach schools, places of work, and public transit. It's now become a place where people from different places and backgrounds cross paths each day. This space where 3 wards meet is the perfect place to celebrate and remember the Harmonium Cemetery and to keep the memory of the Colombian Harmony Society achievements alive. Thank you for the opportunity to testify.
Thank you, Mr. Fay. Mr. Duramo?
Thank you very much, Mr. Chairman, council members. Thank you for considering this bill. Thank you for inviting our testimony today. My name is Miguel Trindade Duramo. I serve as Commissioner for Meridian Hill, and I'm also the Chairman of ANC 1B, which is the U Street Commission. I'm pleased to appear alongside my fellow commissioner and friend, Matt Fay, who represents Ledroit Park and the parcel of land under discussion. He's also the Secretary of ANC 1B. Mike Hewling, unfortunately not able to join us at this late hour, the president of the Ledroit Park Civic Association. He also chairs a committee for ANC 1B, and Alex Padro, the executive director of Shaw Main Streets, who's done tremendous work highlighting the history and legacy of the Harmonian Cemetery that we're referring to today. I'm here to convey that last July, ANC 1B unanimously passed a resolution supporting the Harmony Park Designation Act that's under consideration today. And I'll just read a couple of the clauses of that resolution into the record here on behalf of my commission. The commission noted that the Colombian Harmony Society was a mutual aid organization founded in 1825 by a group of free Black men of the District of Columbia for the purpose of aiding its members in infirmity, sickness, disease, or accident, and to provide burials for them after death. As one of its first actions, the society allocated $100 for the purchase of suitable land for a cemetery to serve the free Black community. And in 1829, they purchased Square 475 in Washington City, which is bordered by Florida Avenue, 5th Street, S Street, and 6th Street Northwest, to create the Harmonian Cemetery. The Colombian Harmony Society and the Harmonian Cemetery provided a degree of financial stability for its Black members who were excluded from burial at white cemeteries and often struggled to afford the costs of funeral arrangements and a burial plot. The Harmonian Cemetery also served the poor community, with 1/4 of Square 475 being set aside for free Black residents without means. In 1856, an ordinance prohibited cemeteries in Washington City, forcing the society to relocate the Harmonian Cemetery to a parcel at the intersection of Rhode Island Avenue Northeast and Brentwood Road Northeast, the present site of the Rhode Island Brentwood Metro Rail Station, whose development forced the cemetery to relocate a second time to Maryland. And of course, as I expect Mr. Padro will be telling us, that history was quite tragic. And while most of the human remains were relocated to Maryland, some were not and have been subsequently discovered, which of course is also true of the plot on Florida Avenue. But many of the headstones did not survive the move and were used, piled in the Potomac River in a very undignified way. So there's an effort underway to honor the people who were shuffled more than once in a quite sad history of discrimination and neglect. So I'm proud that we're shining a light on this history and offering a bit of dignity to people who were mistreated multiple times over a couple of centuries. And it's certainly in line with the goals of ANC 1B to lift up the history of the U Street corridor in as many ways as possible. Thank you very much. Thank you very much, Mr. Chairman, and of course to Council Members Pinto and Nadeau for their work on this.
Thank you, Mr. Duramo. Alex Padro.
Mr. Chairman, members of the council and committee staff, I'm Alexander M. Padro, Executive Director of Shaw Main Streets and a 12-term ANC Commissioner representing Central Shaw. Shaw Main Streets is the neighborhood's historic preservation organization in addition to spearheading commercial revitalization here. Researching and promoting the neighborhood's history is an important part of our mission, especially the neighborhood's rich African-American history. In 2022, Shaw Main Streets discovered a map with the only known illustration of the Harmonian, one of the city's earliest Black cemeteries. The cemetery was on Square 475, bordered by Florida Avenue, 5th Street, Rhode Island Avenue, and 6th Street Northwest. The cemetery operated from 1829 until 1857, when cemeteries were outlawed in the city. Most of the burials were transferred to the new Colombian Harmony Cemetery in Washington County, now Northeast Washington, and in 1959 to National Harmony Cemetery in Landover, Maryland. In 2023, with funding from Humanities DC, Shaw Main Streets created a website, video, and brochures on Shaw's lost African American cemetery. The website URL is harmonianshawdc.com. Today, there is no visible evidence of the cemetery's former presence, as the block was redeveloped in the late 19th century. But based on anecdotal evidence, we believe that some burials remain on the site. Because the only public space on the block consists of an alley, sidewalks, and front and side yards, there is no place there to memorialize the cemetery and the souls whose remains are still located there. The creation of the park, proposed to be named Harmony Park in 2025 as part of a DDOT project that closed a section of S Street Northwest, provides an opportunity to designate a space where the presence of the former site of the Harmonian Cemetery and its internees a block away can be recognized and celebrated. Shaw Main Street foresees annual ceremonies observing the cemetery and celebrations of the souls that found their rest, permanently and otherwise, commemorative sculpture, and interpretive signage. The name Harmony Park aspires not only to acknowledge the Harmonian, but also the park's location at the boundary of 3 wards, 1, 2, and 5. Although ward boundaries may change in the future, the spirit of unity and the spirits of the Harmonians' present and past burials will persist for generations to come. The naming of Harmony Park is an important step in the healing process for the disruption of the eternal rest of the Washingtonians buried at the Harmonian. Thanks to Councilmember Pinto for introducing this legislation and to Councilmembers Nadeau and Parker for their support. Thank you for taking the time to listen to my testimony. I'm available to answer any questions you may have for me now or after the hearing.
Thank you. And let's see, Mr. Hewling, I have a statement, but he's not here. And I do not have your statement, Mr. Duramo, or the ANC's resolution. We would like both of those. And Mr. Padro, your statement would be helpful as well, if you would provide that. The legislation says that this is a symbolic designation. Is it symbolic or official? Who can speak to that?
I believe that it's actually a formal naming because it is the park does not have an official name. So I believe that was an error in the transmittal or in the legislation.
Anybody disagree? Does the ANC disagree?
No, the current space is brand new, which is exciting. It does not currently have a formal name. So having the opportunity to formally name this space and have it designated in a way that not only is placemaking, but also celebrates the history that you've heard, I think would be helpful, and we would support that.
And how close is this to where the cemetery was?
It's a block away. So this is roughly on the 300 block of S Street. If S Street was still there, then there's the 400 block of S Street, and then right there at 5th and S would be the southeast corner of the square that the cemetery was located at.
Yeah. The park is roughly 1 block to the east of where the cemetery was.
On S.
On S.
And who controls the park? Is it DDOT or Department of Parks and Recreation?
It's a DDOT property at this point.
Maybe Mr. Miller, when he comes back, can explain why I believe his statement doesn't speak to this. Wherever he is, don't see him, but yes. Okay, do I have any other questions? So remember copies of your statements, the ANC resolution, and thank you all for your testimony.
Yes,
Thank
and
you
Mr.
for being
Chairman,
here.
ANC 2G also passed a resolution in support back in July of last year, and I'll make sure to forward that as well.
That would be helpful because we do in our reports have a section where we talk about ANC comments. So that would be helpful. Thank you all. Did you have questions? So before we proceed, let me recognize colleagues. I think Councilmember Felder, you were here first.
Thank you, Mr. Chairman. Just wanted to briefly speak on Malachi Jackson. Good evening, everyone. On April 11th of 2022, a Ward 7 resident by the name of Malachi Jackson was shot and unfortunately killed at just 15 years of age by a senseless act of gun violence on the 3300 block of 13th Street Northwest in Ward 1 of the District of Columbia. Malachi loved going to the Rosedale Recreation Center on Gale Street and was an advocate participant in the boxing program throughout his youth. He found a safe space at the recreation center where he could grow, learn, and thrive until his untimely death. With the support of the Rosedale community and Advisory Neighborhood Commissioner of 7D, Councilwoman Brianna Doe, and now we introduce legislation to symbolically designate Gale Street Northeast between 15th Street and 21st Street Northeast as Malachi Jackson Way. The Rosedale community is just one of the many across the district that has felt the devastating effects of gun violence, with far too many young people being killed and families facing unfathomable loss. Through honoring the memory of Malachi Jackson, we hope to raise critical awareness of this issue and bring residents, families, and leaders together to support our youth and work towards ending the gun violence epidemic. Thank you to our witnesses who are here today to share their support of this bill, including Malachi's mother, Miss Ivanka Jackson, and his grandmother, Miss Ivanka Jackson. I look forward to hearing your testimony. Thank you again, and sorry for your loss.
Councilmember Parker.
Thank you, Mr. Chairman. In full disclosure, I will be jumping in and out of today's hearing, but I'm really excited for 3 of the street namings that are up for consideration: Joseph Bowser Way, Ralph Bunch Way, as well as Union Wesley Way. I did want to make a mention that it appears that there are no witnesses for Joseph Bowser Way, and it goes without saying that the entire Ward 5 community stands in celebration for the recognition of such a distinguished leader in our community. I see Anthony Hood in the audience, who I believe is testifying, as well as Robert Vincent Branham. I believe it was listed differently on the public witness list. I also wanted, for the record, to read a brief email from ANC Commissioner Lucio, chair of ANC 5A, the home ANC for Mr. Bowser. And it just briefly states, and I'll make sure this is on the record, Mr. Chairman, as Joseph Bowser was a longstanding member of ANC 5A in the North Michigan Park community, along with serving in many community roles, I wholeheartedly support a street with his name and his memory. I also support the proposal for placing the sign on the street where he lived as a forever memory of his commitment and dedication to this neighborhood. And so again, Mr. Chairman, I'll make sure that you have that. I am told that Carmen Williams, the chair of the North Michigan Park Civic Association, will also offer a formal resolution in support of Joseph Bowser Way. We have Ralph Bunch Way. I believe Commissioner Robert Vincent Branham is here to speak in support of that street designation as well. Commissioner Sun from ANC 5B03 has also offered to write a letter of support. And then lastly, Union Wesley Way, I believe we have here Ira Hobbs, the chairman of the Board of Trustees from Union Wesley AME Zion Church, here to testify in person. And you will be receiving a formal letter of support from Charlotte Lewis, the chair of the Queens Chapel Civic Association. I will conclude by saying this: these 3 street namings are yet another attempt by my team and myself to recognize stalwart leaders from our community, and in particular, African-American leaders with ties to the Ward 5 community. There is no secret that our city and our communities are changing, and change at times can be good. And it is important that we remember those on whose shoulders we stand and who have paved the way for all of us to be here today. So with that, Mr. Chairman, I'm looking forward to our witnesses, and thank you for entertaining my introductory statements. Thank you.
Looks like you provoked Mr. Felder into saying more.
Mr. Chairman, just 30 seconds. I couldn't sit on this dais and not acknowledge a true civic leader of the District of Columbia, which is Mr. Joe Bowser. I commend Councilmember Parker for his leadership to put forth this resolution. I've had the pleasure of meeting Mr. Bowser roughly 10 years ago. And, I was just at awe with his knowledge, specifically getting out into the community, getting to ensure that you make connections, you sell yourself. I'll say one of the last conversations I had with Mr. Bowser was right before I became the council member. I won a primary and I had an opportunity to go past his house and pay him a visit. And at that time, he was losing his sight and he was bedridden. So it wasn't the Mr. Bowser that I was accustomed to engaging with. Nonetheless, I went in this bedroom and I thought he was going to give me a little bit of conversation, but I was very surprised. He asked me two things that I would never forget as long as I'm a civic leader. The first thing he asked me, he said, "Hey, were you knocking on doors long enough to the point that you have holes in your shoes?" And I said, "Yes, sir, I was." And then the next question he asked, he said, "Let me see your knuckles." And I said, "Why do you want to see my knuckles?" And he said, "If you do not have coming from your knuckles, then that means that you were not putting in the work." So I will always remember and appreciate him for those questions, but most importantly for his leadership and contribution to the District of Columbia. So with that, Mr. Chairman, I defer back to you.
Thank you. Thank you, each of you. So let me, I'm going to call the next four bills, and I think we have two witnesses. 26-365, Lenora Baker Wade Designation Act. Bill 26-415, Joseph Bowser Way Designation Act. 26-437, Stronghold Way Designation Act, and Bill 26-550, Ralph Bunch Way Designation Act of 2025. I have two witnesses, Robert Vincent Branham and Anthony Hood. Is Mr. Hood still here? Yes. And while you guys are coming up, Lenora Baker Way was introduced by Councilmember Allen on September 23rd of last year, and it would symbolically designate 3rd Street Southwest between I and M as Lenora Baker Way. Bill 26-415, Joseph Bowser Way designation was introduced by Councilmembers Parker, Fruman, Bonds, Henderson, Nadeau, Allen, and Felder on October 6th last year, and it would symbolically designate the 4800 block of 7th Street Northeast as in Ward 5 as Joseph Bowser Way. And it's going to take me a minute. Stronghold Way, Bill 26-437 was introduced by Councilman McDuffie on Monday, October 20th, 2025. Even though he stepped down, the bill is still with us, and it would symbolically designate the alley that runs through the Stronghold neighborhood in Ward 5, bounded generally by Michigan Avenue, North Capitol Street, and adjacent to Glenwood and Prospect Hills cemeteries, symbolically designated as Stronghold Way. And Ralph Bunch Way was introduced by Councilmember Parker on December 15th. So that's a newbie. And it would symbolically designate 1500 block of Jackson Street Northeast in Ward 5 as Ralph Bunch Way. Mr. Branham?
Greetings and salutations. First, Mr. Chairman, I want to state that my earlier comments were not, my earlier testimony was not directed at you. I just want that on the record. I am Robert Vincent Branham. I am pleased to testify in support of Bill 26415, Joseph Bowser Way Designation Act of 2025. Bill 26437, Stronghold Way Designation Act of 2025, and Bill 26-550, Ralph Bunche Way Designation Act of 2025. However, I draw my particular words to Bill 26-415, Joseph Bowser Way Designation Act of 2025. Joe Bowser and I shared similar experiences. Born in the District of Columbia, former ANC commissioners, active with Ward 5 Democratic Committee. Both Joe and his wife Joan have been guests in my home. Often when Joan would see me, she would ask one question: "How is your beautiful wife?" My reply was always the same: "She's still beautiful." But the one thing which ties Joe and me together and forever is the love of this country as servicemen in District of Columbia. While others have and will speak on the gallantry of service of others today, I come to testify at this hearing to honor a friend, Joe Bowser. It is unfortunate that one must sit at the right hand of God in order to be recognized in this life. I thank you, Mr. Chairman. I also want to thank my councilman for introducing these worthy pieces of legislation. And I thank you, Councilmember Felder, for your words. And I'm pleased to sit next to a good friend, a good friend.
Thank you. Was that also in your statement? We should get a, you should give us a written copy of your statement, please.
I will.
Mr. Hood.
Well, good afternoon, Chairman Mendelson, Councilmember Parker, Councilmember Felder, Councilmember Allen, other council members and staff. My name is Anthony Hood. I'm a proud Ward 5 resident. I'm honored to speak in support of Bill B 260415, the Joseph Bowser Way Designation Act of 2025. As the songwriter wrote, "May the work I've done speak for me. May the life I've lived speak for me." Mr. Bowser's contributions to Washington, D.C. were significant and enduring. He worked tirelessly to ensure city services met the highest standards and was never afraid to call out areas for improvement. His commitment to excellence was matched by his dedication to mentoring others, always encouraging, advising, and challenging us to be better. I recall many conversations where he pushed me to think critically and responded thoughtfully. If my answer fell short, he would say, "Anthony, you're talking to me now," reminding me to rise to the occasion. That was his way of making us the best we could be in service to our community. To many of us, Mr. Bowser was a mentor, a father figure, teacher, friend, and civic leader. My personal relationship spans over 44 years and always centered on what was best for the people of Washington, D.C. I debated on whether I was going to tell this story, Mr. Chairman, but one of the times I was down here testifying in our oversight hearing, one of my first times, Mr. Bowser stopped me. I mean, he would always do certain things and make sure you go down there prepared. I don't know if you remember this, Mr. Chairman, but he didn't think I was prepared. I thought I was, and I guess you did, because I don't think you asked me a whole lot of questions. But before I could get up from this table, my phone was ringing. So I know he was watching it, and I looked up and I got my phone. It was Mr. Bowser, but you had dismissed us. So I stood up and I went outside and called. And I got a great lecture of what I should be doing. So as a result of that, a lot of times when he knew I was coming for the oversight hearing, nobody would have never known this, but I'm gonna tell it now. I used to have to work with him, and he would drill me and ask me questions. And I remember one specific question during the budget. He says, "Anthony, how many lawyers do you have?" And you may remember some of this. I said, 8. He said, "No, you don't, you have 6. He was always sharp. He always knew what was going on. Oh, my time is up. So I extend my sincere thanks to Councilmember Parker.
We give extra time for stories.
Okay. I have plenty of those. I extend my sincere thanks to Councilmember Parker, the council, and everyone who supported this designation. Today's list of honorees as well are remarkable. And I will tell you as well, I think Councilmember Parker already mentioned it. I did speak to Commissioner Lucio and also Carmen Williams. They support as well. So thank you. And this is a great, great designation along with others. Thank you.
Thank you. I don't think I have questions for either of you. Mr. Hood, I have your statement.
Thank you.
Mr. Branham, you're always good about giving us statements, so you'll get us yours. Councilmember Felder, do you have any questions?
No, Mr. Chairman, not at the moment.
Councilmember Parker?
Yes, thank you both for your testimony. I want it on the record that the seed for the Joseph Bowser Way came from Anthony Hood. There were several occasions after the passing, after Mr. Bowser passed, where Mr. Hood said, "Can we get a street designation? Can we get a street designation?" I think some of our earlier conversation, I was reminding you of council policy. Well, the chairman wants us to wait 2 years. You say, "Oh, I'll talk to the chairman. Let's just get the street designation in." And so I want it on the record that I know what your relationship with Mr. Bowser meant to you, and that this honor is a seed from that relationship. So thank you for that. A few questions I have. I know Mr. Bowser started the North Michigan Park Civic Association. What are some of the other accolades that you are aware of that is worth putting on the record? And this is for either one of you all.
Well, he was definitely involved with the Civic Association, the Citizens Advisory Council. And I'm not Catholic. He was Catholic, but I'm not sure he was at the top of what the Catholics do in the church. He did a number of things. He was in different organizations, the Kiwanis Club. One of the things that I found that was most, he would always tell me about his uncle at Eagle Harbor. His uncle helped incorporate Eagle Harbor. I would be remiss if I didn't tell that story, but while I have the mic, I do want to thank Ms. Joan Bowser for allowing me the many times I've called the house, the many times I've sat in the living room, the many times he and I hung out on the porch, the many times he and I went to community meetings. So I just wanted to put that on the record. But those are some of the things that I remember. He was very involved in a lot of civic activities.
Councilmember, thank you. When I was chair of the Ward 5 Dems, Joe was always at the meetings, always contributing and being Joe Bowser. And I learned a lot how to run the Ward 5 Dems meetings from him. And as a reflection of that, I want to make following his legacy, there's going to be a meeting of Black men to talk about and organize issues around health, voting, and holding elected leaders accountable. And that's going to be Saturday, February the 7th, 2026, from 10 to 2:30 at Matthews Memorial Baptist Church on Martin Luther King Jr. Avenue. And you can register at mmb.eventbrite.com. And I'm sure, this reflects the kind of work that Joe was actively engaged in the community. And this would be a wonderful example. And I thank you, Mr. Chairman, for allowing me that plug.
Well, thank you. I will just conclude with a story of my own. No one mentioned that Mr. Bowser loved manning the polls well into his.
He was always there at 66. He was always there.
And I will just end with this. There was a little educator that decided to run for the State Board of Education, and nobody knew who this guy was, but Joe Bowser took a chance on him. And so I would say I am forever indebted to his trust and his leadership. And I would agree as well, the same goes for Joan Bowser. and they were a very loving couple. Thank you all for your testimony. Last question from me. Are there any objections to Ralph Bunche Way, which also would be designated in our community?
I have no objection. In fact, I am supporting that designation, and also Stronghold Way. And also I would add my name to the Union Baptist Union Church designation also.
And Councilmember Pryor, I would say this was a great list. Rodney Wright, this is a great lineup, great list. Kudos to everyone who's involved with this. And thank you, Mr. Chairman and council members.
Awesome. Thank you.
Thank you. Thank you for your testimony. I will note, because you brought up the 2 years, so we'll probably move this in the fall, because it'll be 2 years. Somebody did not talk to us. Somebody did not talk to me.
You can talk about another issue, but Mr. Chairman, I figured everything was straight. So I thank you. Thank you. Appreciate your support
It will move.
on moving it
It will move.
before the fall.
It will move. Thank you. Thank you all. So I have Bill 26-431, Rodney Wright Basketball Court Designation Act, which I have no witnesses listed, was introduced by Councilmember McDuffie on October 16th, would name the basketball court at Marvin Gaye Recreation Center on 61st Street Northeast as Rodney Wright Basketball Court. And Bill 26-432 also does not have any witnesses signed up, but the Department of Transportation will. That's the Roland Fatty Taylor Way Designation Act of 2025, also introduced by Councilmember McDuffie on October 16th of this year, of 2025, to symbolically designate the 200 block of 62nd Street Northeast as Roland Fatty Taylor Way. And that brings us to Bill 26-435, Malachi Jackson Way Designation Act of 2025. I do have several witnesses. Alvanica Jackson. Alvanica, my apologies, and Alvancia Jackson. PJ Alderman. Aaron Davidson. Robin Wynn. I have two more. Mark Friend, but I don't have chairs. Mark Friend. Oh, you're Mark Friend. No, you're PJ. All right, I need a name check. Yes. 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 Who's not on the list? Yes. And he's not here. Okay. We do have a statement. Okay, so your name is? How do you spell your last name? B-E? Okay, and your first name?
Yeah, A-L-E-A.
Okay. So let's begin with Alvanica Jackson.
Good morning. My name is Alvanica Jackson. Malachi was my child. He was not a statistic or a headline. He was loved deeply, dreamed freely, and had a future that should still be unfolding. There is a weight that no parent should ever have to carry, the weight of burying their child and wondering if their life truly mattered to the system meant to protect them. Naming Malachi Jackson Way is not about remembrance. It is about acknowledgement. It is about saying publicly and permanently that our children's lives have value, that their loss is not invisible, and that as a community and as leaders, we hold ourselves to a standard of accountability that does not tolerate the taking of innocent lives. As a mother, this honor allows Malachi's life to be more than a tragedy. It allows his name to carry purpose, to speak where my voice alone cannot, and to challenge us to create a safer future for our children. Thank you for your time and to considering this. Gun violence does not end with the person who is killed. In the loss of Miss Renee Good, her children are left to grow up without their mother's protection, guidance, and love, carrying that grief into every milestone of their life. We cannot accept gun violence, whether the person is Black or white, young or old, rich or poor, wearing a uniform or walking down the street. Every life matters. Every child deserves a parent, and every parent deserves their child. I would ask this committee and chairman and council members to approve the honorary street into law. Repeated gun offenders should not be allowed to murder innocent children, women, or other men, and families will live with that pain forever as we ask for remembrance, understanding, and protection as human beings. Thank you.
Thank you for your statement. Thank you for your courage to be here and to read the statement, and sorry for your loss. Ms. Alvancia Jackson, am I pronouncing it correctly? And yes, microphone.
Thank you. Thank you for this panel, taking this time out with us. Yes, we are a grieving family. Still yet, the pain do not go away. As a mother, a pastor, a friend, aunt, cousin, and a grandmother, I face a daily challenge in coming to terms with the absence of my grandson. Malachi Jackson, each morning, I remember his smile, his face, his laughter. He looks just like me. I must remind myself that he is no longer with us. Without this acknowledgement, starting my day proves difficult. The impact of the assault has profoundly altered my life forever. The passing of the location evokes significantly anxious, anxiety. Comparing our lives before and after the incident is deeply painful. Malachi was 15 years old when he was taken from us. He is now 19 in heaven. His smile, laughter, and cheerful greetings is greatly missed. This experience serves as a reminder how quickly life can change. I respectfully ask that the courts to allow us to honor his memory and demonstration compassion for one another through the name of this street. Although we are dissatisfied with the outcome of the Malachi Jackson case, dedicating a street in his name can prove closure and help us encourage for his legacy endurance. Passing by Malachi Jackson Way will ensure us that we have done everything possible to remember him and preserve his name. It will serve as a lasting tribute, ensuring that he did not die in vain and that his memory continues to brighten in our eyes. Thank you.
Thank you. And to you as well. Thank you for your courage to be here. Aaron Davidson, yes, no. Robin Nguyen.
I'm here today to basically say that I think this street name being in my nephew's honor is important. It's important to me because it would be a reminder that all lives matter and I feel this is to speak out and show that my nephew and all others that are not here today due to gun violence are not forgotten. Someone took my nephew's life and I just know my sister did I'm sorry, this was written. My sister did basically what she was supposed to do to basically get here today. Yeah, there's so that I'm sorry. I wrote it in this, but basically that's just what I wanted to say. I'm sorry, Steve.
Okay, I do have a copy of what you wrote, so thank you for that. Ms. Beasley?
On behalf of Malachi Jackson and the Jackson family as a whole, we are honored and count it as a privilege to have the name of Malachi Jackson held in such high regard for all to see, and that his life and legacy always be remembered by those who knew him and by those who never met him, just by saying his name, by walking on the street, or just by driving on it. We thank you for not allowing him to be forgotten and always having a spot in history where he was born and raised. Thank you.
Thank you, Ms. Beasley. And if you want to submit a copy of your statement, please do.
Yes, sir.
Because what we do is when our process is one where the committee has a hearing, that's what we're doing today, then we mark up the legislation, which means we file a committee print, a copy of the bill, but it's been gone through general counsel. That means the lawyers, and then we have a report that goes with it, and we attach the testimony to the report.
Yes, sir.
And that'll happen sometime in the next couple of months. And then it goes to the full council for a vote in the committee of the whole, and then for the council, we vote twice.
Yes.
So that should all happen probably in the next couple of months. So I just appreciate you all being here, taking the time to come down here, but also it's obvious this is hard. And I think that too often we forget the pain that's left behind by these senseless acts of violence. So I don't have any other questions for you. Thank you, each of you, for your testimony. Next on the list is Bill 26-533, San Romero Plaza Designation Act of 2025. Abel Nunez, Executive Director, Carson Central American Resource Center. Manuel Ernesto Nussbaumer, Community Engagement Coordinator, Carson DC, and Rosa Briones. So I got two folks. That means.
Yeah, that was from the same organization, so it's only gonna be one testimony.
Okay. Mr. Nunez, you want to go first?
Yes, thank you. So good afternoon, Chair Mendelson and members of the council staff. My name is Abel Nunez. I am the Executive Director of the Central American Resource Center, known as CARECEN. I'm here to testify in strong support of Bill B 260533, the San Romero Plaza Designation Act of 2025. Before continuing, I want to thank the council for its leadership in declaring August 15th as St. Romero Day in Washington, D.C., a date that honors his birth and legacy for the Latino community. This recognition underscores the district's commitment to justice and inclusion, and today's proposal builds on that important work. The proposal designation of the San Romero Plaza carries profound meaning to our community, and beyond, it honors Saint Oscar Arnulfo Romero as the voice of the voiceless. Romero rose from a humble beginning to become Archbishop of San Salvador in 1977. Initially seen as a conservative, his perspectives changed when witnessing the brutal assassination of his friend, Jesuit priest Rutilio Grande. From that moment, Romero became a fearless advocate for the poor and oppressed, condemning systemic inequality and government-backed violence during El Salvador's civil unrest. His weekly homilies, broadcast nationally, gave hope to millions and called for peace and justice. Tragically, Romero was assassinated while celebrating Mass in 1980, a killing later attributed to right-wing forces. He was beatified in 2015 and canonized by Pope Francis in 2018, recognized as a martyr and a global symbol of faith-driven social justice. San Romero Plaza will serve as a civic landmark that reflects the values of Romero's champion: justice, solidarity, and the defense of human dignity. For Salvadoran immigrants, many of whom fled violence and built new lives here, the plaza will honor their sacrifice and resilience. For members of the Catholic faith, it will be a sacred space to remember a saint who lived and died for his convictions. For those committed to social justice, it will stand as a public reminder of the moral imperative to protect the vulnerable and speak out against oppression. This designation is especially important now at a time when vulnerable immigrant communities face renewed attacks from the federal government. Policies that disregard due process and undermine basic human rights. We need role models who exemplify courage, compassion, and moral clarity. St. Romero's life reminds us that silence in the face of injustice is not an option. His example calls us to stand firm for dignity and fairness, even when it is difficult. San Romero Plaza will reinforce community pride and resilience. It will serve as a venue for cultural events, advocacy, and civic engagement. The enduring contributions of Salvadoran and immigrant communities in Washington, D.C. For youth, it will inspire pride in their heritage and encourage civic participation. For the broader D.C. community, it will stand as a beacon of justice, compassion, and unity, values that Romero lived and died for. Thank you for the opportunity to testify and for considering this important designation. San Romero Plaza will not only honor a saint and a champion of human rights, but would also affirm the district's commitment to justice and inclusion at a time when these values are urgently needed.
Thank you for your testimony, Ms. Briones.
Good afternoon, dear council members. My name is Rosa Briones, and I came from San Pedro Sula, Honduras, 36 years ago, and I began a journey of faith and family. Brought me here to the United States, and I am married. I'm blessed with 2 children. My daughter, guided by the Holy Spirit, and is pursuing a master's degree with the Diocese of Washington and discerning a vocation to the BA priesthood. From the beginning, my life here has been sustained by God's grace and the open arms of the Episcopal Church. In this sanctuary, I found not only welcome, but a living witness of Christ's love. The Episcopal Church has been for me a place of freedom, openness, and profound spiritual renewal. Serving as a deacon, I have seen how God calls us to serve the poor, to lift up the vulnerable, and to walk in solidarity with those who suffer. In 2002, when a hurricane struck, our parish organized a committee to send clothing and aid. At that moment was more than charity. It was a revelation of God's power working through his people. It showed me how faith is not only prayer, but action, how the church becomes the hands of Christ in the world. My journey has also been shaped by the movement of Monsieur Oscar Romero. Traveling to El Salvador too many times, I stood in the chapel where he was martyred. In that sacred place, I felt the presence of God so strongly that it was as if I stood within the very body of the church itself, united with the sisters, some of the witnesses, his sacrifice. Romero's blood became a seed of faith, and his courage continues to inspire me to serve my community with devotion. For me, Romero is not only a saint of the Catholic Church, he is a prophet for all of us in Central America and beyond. His life tells the word that God's justice is real, that his love is stronger than oppression, and that his people will never be abandoned. The creation of San Romero Plaza in Washington, D.C. will be a living testimony to this truth. It will be a place where families can sit over there, pray, reflect, and share the story of a man who gave his life for his people. It will be a beacon of faith and justice in our nation's capital. Remind all who visit that God's love is alive in the struggles and hopes of immigrant families. I urge you to support the San Romero Plaza Designation Act of 2025 is doing so. You will affirm not only a community's heritage, but also the enduring power of God called to justice and mercy. Thanks for hearing my report.
Thank you, Ms. Briones. This is in the area of 16th and Park Road and,
That is correct, yes.
and it's that Triangle Park or?
No, that's federal land. This would be the park that's between the, what is it, that Embassy 40, that building that used to be the Department of Recreation and the church.
So it's perpendicular to 16th Street.
Correct.
Okay. And I think it's an official naming.
That is
The
correct.
bill doesn't say that clearly, but I think it is. And I think DDOT did not testify to this or will not be testifying to this. So we're going to have to figure out who is which agency is responsible.
Yeah, I believe it's DDOT.
Okay. Well, they're here, so we're happy to blame them. I don't have any questions for you, either of you. Thank you very much for your testimony. And I do have your statements, and it's helpful to have you here in person. I didn't say this before you sat down. This bill was introduced by Councilmember Nadeau on December 8th last year. So thank you.
Thank you so much.
We will turn to Bill 26-534 entitled Charlie McCormick Way Designation Act of 2025. We have one witness, Catherine McCormick, if she's here. She's online. This bill was introduced by Councilmember Nadeau on December 8th, this past month. And it would ceremonially designate or symbolically designate the 2500 block of Champlain Street in Ward 1 as Charlie McCormick Way. Okay. Ms. McCormick, you're online. Please proceed.
Thank you. I hope you can hear me. Dear council members, thank you so much. I am writing and speaking to you in support of Bill 26-534, Charlie McCormick Way Designation Act of 2025. I urge you to symbolically designate the 2500 block of Champlain Street Northwest as Charlie McCormick Way. This would recognize Charlie for his 35 years of supporting a vibrant Adams Morgan neighborhood and his advocating for bicycling throughout the DC area. Sadly, Charlie passed away in May of 2023, but his influence lives on in an active bicycling culture in Washington, D.C., and in the continued vitality of Adams Morgan and Unity Park. Charlie was a young, inexperienced, but enthusiastic business owner in 1987 when he took an abandoned filling station on the corner of Champlain and Euclid and turned it into a bike shop, focusing on the bike messenger community, because before we had DocuSign, every document had to be couriered around the city, and the need that they had for repairs. Over the decades, City Bikes expanded to 4 more shops, including Electricity Bikes in the 2010s. Charlie took a great interest in furthering a positive climate around the store and in Unity Park, and you would be happy to see it today. Farmers markets, the Line Hotel, vintage clothing, sales on the sidewalk, and in the 2501 Champlain location where he had his shop, a bike shop and a vinyl store are now thriving there. In the early 1990s, Charlie also purchased the 2503 Champlain building, and an early tenant was a Ben & Jerry's ice cream franchise. Together, they put up a mural depicting the Ben & Jerry's cows riding bicycles and eating ice cream. And this was painted on the outside wall of 2503 above 2501. And it is still visible today. I encourage you to take a look at it. It is one of the stops on a self-guided mural tour of Adams Morgan. In 2001, Charlie was helping the Washington Area Bike Association plan a ride on September 21st with 10,000 cyclists and an accompanying 40-mile street closure. Well, we all know what happened on September 11th, and the district administration wanted to close all streets and discourage large group gatherings. But Charlie bought 10,000 American flags and renamed it the DC Resiliency Ride, and he camped out in the mayor's office until he could persuade officials to let the ride happen. This is just one of many examples of his advocacy and his tireless pushing for various modes of transportation throughout the city. I hope you will give this bill positive consideration. My brother Charlie would be so honored. Thank you. And I think you also have received letters from a number of other organizations, the Washington Area Bike Association, the Adams Morgan Business Improvement District, and the director of the Rails to Trails Conservancy.
Thank you, Ms. McCormick, for your testimony. Yes, we have received others. I don't know if we've received everything you mentioned, but we'll look. But we have received some. You're mentioning that mural. I'd forgotten. That mural was controversial when it went up because the city claimed it was a billboard, advertising billboard. And it was just a bunch of cows on bicycles.
Well, it is still there today, even though it has faded over the many years, but you can still see it clearly today.
Great. I don't have any other questions for you. Thank you for your testimony.
Thank you.
We're going to turn to Bill 26-551, Union Wesley Way Designation Act of 2025. Ira Hobbs, Chairman of the Board of Trustees, Union Wesley AME Zion Church. While you're coming forward, this bill was introduced by Councilmember Parker on December 15th, last month. It would symbolically designate a portion of the public alley system in a square bounded by Queens Chapel Terrace, Michigan Avenue, Eastern Avenue, and Crittenden Street, designated symbolically as Union Wesley Way. I just want to note, after this bill, we will hear from Mr. Miller, DDOT's testimony on all of these bills. Then when we're done with this hearing, we will take up the next hearing, which is on the renaming of a school, which I don't have right in front of me, but I will shortly. Mr. Hobbs.
Good afternoon, Mr. Chairman and the committee as a whole. My name is Ira Hobbs, and I serve as the chairman of the Board of Trustees at the Union Wesley African Methodist Episcopal Zion Church. I'm here today to testify in support of Bill B26-0551, the Union Wesley Way Designation Act of 2025. Our request is simple but deeply meaningful: to designate the alleyway running parallel to our church at 1860 Michigan Avenue Northeast as Union Wesley Way. The designation is not just about a name on a sign. It is about memorializing a legacy of resilience, faith, and over 180 years of service to and within the District of Columbia. To understand why this designation matters, we must look at where we started. Union Wesley had humble beginnings in Georgetown in 1844. Born out of a desire for religious freedom amidst a climate of racial prejudice, a small group of men and women formed an independent church, originally meeting in a home at 28th and Olive Avenue Northwest. As the congregation grew, they moved to 23rd Street in 1846. However, the racial prejudices of that era struck violently, and our early framed houses were destroyed by fire. But acts of terror could not kill the faith of those brave men and women. They refused to give up. Instead, they partnered with a young Black architect named Calvin Bent, who designed and constructed a new red brick church on that very same site in 1848. That building, then known as the Second Colored Wesleyan Church, became a beacon of hope. It served as a station on the Underground Railroad enslaved people were not only hidden, but taught skilled trades like carpentry to aid in their quest for freedom. In 1967, facing the pressures of urban renewal and displacement in Georgetown, the congregation, led then by Reverend Dr. George Lincoln Smith, made the difficult decision to relocate. We sought a place where we could continue to be a vital part of the community. We found that home in the Avondale community of Northeast DC, our current location on Michigan Avenue. Since arriving in Avondale in 1967, Union Wesley has been a pillar of support for over 6 decades. We have served as a central meeting center for the community association and numerous other auxiliaries within the community. We have hosted district leadership and numerous programs that have improved our ward and the district as a whole. Our commitment in this neighborhood has been most recently recognized repeatedly. In 2023, we were honored with the Grassroots Award by the DC Federation of Civic Associations, following a nomination by the Queens Chapel Civic Association. Just last year, in 2024, this very council honored us with a resolution celebrating our 60th year of partnership and service. This designation has the full blessing of the Queens Chapel Civic Association, reflecting our deep-rooted relationships with our neighbors. In conclusion, designating the alley Union Wesley Way is a way to forever memorialize our presence and our unwavering commitment to this community. It honors the journey from a burnt-down framed house in Georgetown to a pillar of the Northeast community, a journey defined by resilience, service, and faith. We give thanks to Councilman Parker for submitting this legislation. On behalf of our pastor, Reverend Dr. Brian S. Relford, the Board of Trustees, and our entire congregation, I respectfully ask for your support of Bill B-26-0551. Thank you for your time. Thank you for your service to the district.
Thank you, Mr. Hobbs. I don't have a copy of your statement.
Chalk that up to a lack of knowledge of the process, sir. I will make sure that you get this. I will send it in.
Please, because it would be very helpful. It's a good statement. It gives a lot of the history, which is helpful, and we will include it with the report.
Yes, sir.
So
you should also be receiving letters of endorsement from the Alpha Kappa Mu chapter of AKA Rho Omega. You will be receiving one from the program College Bound. You will also be receiving a letter from the Queens Chapel Civic Association, a couple of lawyers in the community, and others.
I'll forgive you for the lawyers. I have a statement here from Ronald Jessamy.
Yes, sir.
He must be one of the lawyers.
He's one of the lawyers.
Yep. Thank you very much.
Thank you, sir.
We will turn now to Mr. Brant Miller. Welcome back, and when you're ready.
Good afternoon, Chairman Mendelson, members of the council, staff, and district residents. My name is Brant Miller, Manager of Policy and Legislative Affairs at the District Department of Transportation, commonly referred to as DDOT. I'm here today to present testimony on behalf of Mayor Muriel Bowser and DDOT Director Sharon Kirschbaum regarding the following bills. Bill 26308, the Jules Way Designation Act of 2025. Bill 26365, Lenora Baker Way Designation Act of 2025. Bill 26415, Joseph Bowser Way Designation Act of 2025. Bill 26432, Roland Fatty Taylor Way Designation Act of 2025. Bill 26435, Malachi Jackson Way Designation Act of 2025. Bill 26437, Stronghold Way Designation Act of 2025. Bill 26534, Charlie McCormick Way Designation Act of 2025. Bill 26550, Ralph Bunch Way Designation Act of 2025. And Bill 26551, Union Wesley Way Designation Act of 2025. The stated purpose of Bill 26308 is to symbolically designate 13th Street Northwest between Upshur Street Northwest and Allison Street Northwest as the Jules Way. For visualization purposes, I have attached to this testimony a copy of a DDOT generated map highlighting the relevant section of 13th Street Northwest. Sufficient signage requires 2 signs totaling $255, $65 for sign fabrication, and $125 for sign installation. The stated purpose of Bill 26365 is to symbolically designate 3rd Street Southwest between I Street Southwest and M Street Southwest as Lenora Baker Way. For visualization purposes, I have attached a copy of a DDOT generated map highlighting the relevant alley system. Sufficient signage requires installation of 7 signs totaling $580. The stated purpose of Bill 26415 is to symbolically designate the 4800 block of 7th Street Northeast as the Joseph Bowser Way. For visualization purposes, I have attached a copy of a DDOT generated map highlighting the 4800 block of 7th Street Northeast. Sufficient signage requires installation of 2 signs totaling $255.
Let me interrupt you for a
Yes.
second. So Lenora Baker's 7 signs for 580, but it's 255 for 2 signs.
I believe that there is an error in the 2 sign tally. I think that we erroneously included the cost of a pole when there is not one needed, and that's how we arrived at 255. So when we resubmit our testimony with the updates that I'm sure we will get to later, we will include the adjusted number, which will be, I think, sorry, I double checking. It will be $130 instead of $255 for 2 signs.
I'm doing some math. 260, 390, 390, and 1 is yeah, all right. I guess that gets close to 580. I interrupted you. You're at Bill 26-432.
The stated purpose of Bill 26432 is to symbolically designate the 200 block of 62nd Street Northeast as Roland Fatty Taylor Way. For visualization purposes, I have attached a copy of a DDOT generated map highlighting the 200 block of 62nd Street. Sufficient signage requires installation of 2 signs totaling $255, $130. The stated purpose of Bill 26435 is to symbolically designate the Gale Street Northeast between 15th Street Northeast and 21st Street Northeast as Malachi Jackson Way. For visualization purposes, I have attached to this testimony a copy of a DDOT generated map highlighting the relevant section of Gale Street Northeast. Sufficient signage requires the installation of 12 signs totaling $905. The stated purpose of Bill 26437 is to symbolically designate the alley that runs through the Stronghold neighborhood in Ward 5, bounded generally by Michigan Avenue Northeast and North Capitol Street Northeast as Stronghold Way. For visualization purposes, I have attached a copy of a DDOT generated map highlighting the relevant alley system with the Stronghold neighborhood. Sufficient signage requires 13 signs and 1 pole totaling $1,250. I believe there has been a misunderstanding about what alley system is being named. And so we actually will not require 13 signs for this. I believe it will be closer to 2 to 4 signs, not 13.
So I'm looking at the map.
Yes.
And I'm assuming north is at the top. So there's a north-south, and then it looks like there's a diagonal to the east. And I'm guessing the diagonal to the east should not be part of this?
Correct.
Okay. Sounds good.
I interrupted myself that time, so now I have to. Okay. The stated purpose of Bill 26534 is to symbolically designate the 2500 block of Champlain Street Northwest in Ward 1 as Charlie McCormick Way. For visualization purposes, I have attached to this testimony a copy of a DDOT generated map highlighting the designated alley system. Sufficient signage requires 2 signs totaling $130. The stated purpose of Bill 26550 is to symbolically designate the 1500 block of Jackson Street Northeast in Ward 5 as Ralph Bunch Way. For visualization purposes, I have attached to this testimony a copy of a DDOT generated map highlighting the designated alley system. Sufficient signage requires 2 signs totaling $130. The stated purpose of Bill 26551 is to symbolically designate the public alley system in Square 4176, bounded by Queens Chapel Terrace Northeast, Michigan Avenue Northeast, Eastern Avenue Northeast, and Crittenden Street Northeast as Union Wesley Way. For visualization purposes, I have attached to this testimony a copy of a DDOT generated map highlighting the designated alley system. Sufficient signage requires 2 signs totaling $130. The total cost for sufficient signage, including poles for these bills, it's updated to reflect the $130, is $3,765. DDOT can absorb the cost of these signs and poles within its current budget and does not foresee any operational impact on the district's transportation network. Therefore, the administration has no objection to these street and alley namings. DDOT stands ready to assist the council and all other stakeholders with any ceremonial unveiling activities that may materialize as a result of these bills being passed. Thank you for allowing me the opportunity to testify before you today. I'm available to answer any questions that you may have.
Thank you, Mr. Miller. So your plan is to resubmit your statement with corrected numbers?
That is correct, yes. And updated maps to reflect the changes, yes.
And you'll work with Mr. Cash because we will probably need, instead of 2 maps on a page, maybe just a single map on a page for each report.
Yes.
Harmony Park, Bill 26-231 is not in your testimony. There was some testimony that it's a DDOT property.
There was testimony to that effect. I believe I can speak to 2 bills at once when I say there was a misunderstanding about who the property belongs to, and we will follow up with our right-of-way team and follow back up with you. The other would apply to the
San Romero.
San Romero, yes, Plaza. It's the same misunderstanding about who the property owner is. So we will follow up with our right-of-way team and get back to you about that.
Okay, who the owner is means either DDOT or DPR?
Most likely, yes.
And you probably are not in a position to say right now what the executive's position is on them.
Correct.
And I believe those are both official names. Those are the only official names, right? Greens Court Park, did you testify on that?
No.
So that's in the same, I could say boat or I could say park in the same park.
I don't know if there was a misunderstanding about who owns that, but what we can do is certainly get the plats for those properties and submit them with our updated testimony, so you have them for the record.
Yeah, and then we also have that basketball court.
That is very likely not a DDOT property, but I will work with my colleagues to make sure that you get the necessary plats for the record.
Morale would be better if there was basketball within DDOT, just saying. All right, so if you could follow up on that one as well.
Yes.
And if it is that DPR needs to comment, if you could get OPLA to tell DPR they need to comment.
Yes, I will work with my colleagues in OPLA to make sure that you get the plats and the records that you need.
Otherwise, we do snotty reports about how the executive didn't care and didn't comment, and you don't want that.
Correct.
Thank you. Give me just a second. I have no further questions for you. Mr. Miller, thank you. I appreciate it.
Thank you.
That is going to conclude this hearing. See if I can find my hearing notice. This has been a hearing on numerous bills that would designate symbolically or officially names for some parks, a basketball court, and some alleys and some streets. The record in this matter will be open for 2 weeks. That is, the record will close at 5 p.m. on January 27th. Anyone who wishes to submit comments on any of these bills has 2 weeks to do so. The time is 3:04, and this hearing is adjourned. I'm going to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. This is the third of 3 hearings that the committee is having today. Today is Tuesday, January 13th, 2026. The time is 3:07 in the afternoon. We are in hearing room 412 of the John A. Wilson Building. The subject of this hearing is Bill 26-364, entitled Gardner Bishop Elementary School Redesignation Act of 2025. This legislation was introduced by Councilmember Charles Allen on Tuesday, September 23rd, 2025. The stated purpose of this bill is to designate the school in Lot 33 and Square 792, which means nothing to most people, bounded by North Carolina Avenue, 4th Street, 3rd Street, all southeast, and in Ward 6 to designate the school as Gardner Bishop Elementary School. The school at this location, currently known as Brent Elementary School, is undergoing modernization, which will be completed for the school year 2027-2028. The school community took the modernization as an opportunity to engage in renaming the school after an individual who better reflects their values. Gardner Bishop was a barber, civil rights activist, and the father of a student at Brown Junior High who fought to equalize and desegregate the district's public schools in the 1940s and 1950s. His activism led to the historic Bowling v. Sharp U.S. Supreme Court case, which found that school segregation in the district was unconstitutional. Bowling v. Sharp accompanied Brown versus Board of Education. I think they both were issued the same day, the decisions. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on January 27th, 2026. We have 6 witnesses who I will call in a minute, but let me turn to my colleague, Councilmember Charles Allen, if you have an opening statement.
Thank you very much, Mr. Chairman. And I know it's been a long day hearing so far. So thank you very much. And to our school community that is still here, thank you for your patience as well. For those who may not know, Brent Elementary School, located on Capitol Hill in Ward 6, has a lot of exciting things going for it right now. The school community is currently swinging at Meyer Elementary School because the current facilities at Brent are being modernized, long overdue. We are excited for the new building. Someone sent me some pictures just the other day of the demolition, so we are in progress. But most importantly, what it's going to help bring to the school community when it comes back online at the start of the 27-28 school year. The Brent community, however, has been very smart and been thinking about utilizing this modernization as an opportunity to remold and chart a new path for its future. At the end of the 2023-24 school year, the community began a process to rename the school and have its namesake, an individual that more appropriately reflected the school's community values. The school community first started by circulating a survey in February of 2025, and it collected a total of 57 name submissions. The school community and faculty then narrowed that list of names down to 2 individuals after weeks of extensive engagement with students, faculty, parents, and caregivers, and considering specific criteria. After 2 more weeks of voting and extensive outreach in May of 2025, the Brent community decided to move forward with Gardner Bishop as its namesake. Who's Gardner Bishop? A very important figure in the district's history and an individual who will more appropriately represent the school community. He was a barber, civil rights leader, an activist, and as Chairman Mendelson just said, the father of a student at Brown Junior High in the district who led the fight to equalize and desegregate the district's public schools in the 1940s and 1950s. There's a lot more that I could say about him, but frankly, we are going to hear from some of the experts in the room in just a little bit. And they are going to help outline a lot of his accomplishments and his legacy. But suffice to say, his legacy is one that more appropriately embodies the school community as well as community-led change and activism. So I was proud to introduce Bill 26-364, the Gardner Bishop Elementary School Redesignation Act of 2025 in September of last year, after the culmination of years of extensive and collaborative community engagement around choosing a new name for the school community. It reminded me a lot about what I saw with the renaming of the Shirley Chisholm Elementary School just a few years ago, which was a transparent, good faith, collaborative, and organic effort that was led by the school community to choose how it wants to define itself and lead itself into the future. And as a policymaker, it's a beautiful thing to see. And I'm grateful for our other public witnesses today, as well as those who aren't here, for their years of hard work and advocacy that have actually gotten us to this point today. So thank you, Mr. Chairman, and I'm looking forward to hearing all of our testimony.
Thank you, Councilmember. Jenny Cheek, Brent Elementary School PTA Co-President. John Berg, teacher at Brent Elementary School. Billy Shute-Pratt. Okay. Who's a student? Megan Brackett, who's with the Equity and Inclusion Group. I have one more seat, Leticia Rojas, Equity and Inclusion Group. And is Cortavia Freeman here? Let's see if we can squeeze another chair. I don't usually do that, but let's see if we can do that. Oop.
What Shirley Chisholm said. Don't have chair, just bring one. Bring your own. Shirley Chisholm joke.
Council members quoting Shirley Chisholm. This is Bishop Gardner, or Gardner Bishop, excuse me, Ms. Cheek.
Thank you, Chairman Mendelson, for holding this hearing, and thank you to Councilmember Allen for sponsoring this bill. My name is Jenny Cheek. I'm a longtime community member, a parent of a Brent Elementary alumnus, and a former co-president of the school PTA. I appreciate the opportunity to testify in strong support of renaming Robert Brent Elementary School to Gardner Bishop Elementary School. As was mentioned at the end of the 23-24 school year, the Brent Equity and Inclusion Group, composed of school staff and student caregivers, including myself, chose to focus our 24-25 efforts on renaming the school. And that would coincide with the final year of the Brent Elementary building, which is being modernized and will open again in 2027. We chose to undertake the renaming effort for reasons important to our school community. First, to articulate the values and beliefs of our community and select a school namesake who better embodies the values and beliefs that we hold. Second, to right historical wrongs by breaking ties with a namesake connected to racism, segregation, and slavery. And finally, to work together across generations, showing the children of our community how they can achieve change and shape the way we honor and commemorate historical figures. Our group coordinated community education, engagement, input, and discussion, after which a new school name was selected in honor of Gardner Bishop. Gardner Bishop lived from 1909 to 1992. He was a barber, parent, and civil rights activist in Washington, D.C. His oldest daughter attended segregated Brown Junior High, which was designated for Black students and was greatly overcrowded with double its intended capacity. Despite there being nearby under-enrolled schools for white students, Black students were required to attend Brown in shifts, receiving less than a full day of instruction. Rightly, Gardner Bishop was outraged. He would not accept the unequal education being offered to his daughter and other Black students in the district. A group of parents known as the Consolidated Parents Group joined forces to pressure the school board to address their concerns, and Gardner Bishop became their spokesperson. In 1949, Gardner Bishop worked with the Consolidated Parents Group to try and enroll Black students at the newly opened John Philip Sousa Junior High, which was reserved for white students. This campaign resulted in the 1954 Supreme Court case Bowling v. Sharp, which held that the segregated public schools in D.C. were unconstitutional. Along with Gardner Bishop, our community considered many notable historic figures to use as a namesake for our school. Ultimately, with input from our school community, 2 finalists were selected, Gardner Bishop and artist Elizabeth Catlett. Every student in the school had the opportunity to learn about both figures, and debate was spirited. After votes were collected, Gardner Bishop was the winning choice. We are proud of our work in selecting a namesake whose life reflects the values of our school, and we look forward to being known as Gardner Bishop Elementary. Thank you.
Thank you, Ms. Cheek. John Berg? Billy Shute Pratt?
It's Billy Sudi Pratt.
All right.
Oh geez, wrong. Before, uh, before I begin, I would like to thank Chairman Mendelson and all the people who helped make this hearing happen, our school's equity and inclusion group, and council member Allen. I think that my school, which is currently named Robert Brent Elementary School, should be renamed as Gardner Bishop Elementary. I think this because this name that hopefully will become my school's name is inclusive. When parents and other people in the community, think of our school they won't think of a racist white guy. They'll think of a parent who saw a problem, and instead of accepting it, thinking there was nothing to be done, he took action. He helped others. The overall outcome of his actions, his knowing that he needed to do something. Anything to help with that, with education, which everyone, no matter of race, identity, gender, or adversity, deserves to have. Gardner Bishop, who was born in 1909 and died in 1992, was a Barbara parent and civil rights activist who lived in Washington, D.C. As said before, one of his kid attended the school, which the kids attended SIFs. The school board decided that the students had to attend that school in SIFs. This was illegal, receiving less than a day of education. Now, I have to skip over. Sorry, just take a step back and realize how crazy this was. They just wanted to keep segregation, and they were allowed to break the law just so that they could keep that. Gardner Bishop was infuriated. A group of parents began meeting regularly to strategize how to pressure the school board to address their issues, and Bishop became the leader, their spokesperson. This became the Consolidated Parents Group. He started a boycott. During the boycott, people didn't go to the school. After that, the school board decided to make use of other buildings so that students wouldn't move through the day. But it didn't stop there. In 1949, he tried to enroll Black students in the John Philip Sousa Junior High School, which was reserved for white students. This resulted in the Supreme Court case, Bowling versus V. So, which said that the segregated schools were unconstitutional. Eventually, the parents and their leader, Gardner Bishop, won the case, ending segregation in DCPS schools. Without Gardner Bishop, it would have taken a lot longer to end segregation in DCPS. This is why Gardner Bishop Elementary Superior School's new name, despite racism, inequality, and adversity, Gardner Bishop prevailed, making a better learning experience, not just for Black and African American students, but for every single student. If a school's name was Gardner Bishop Elementary, they would imagine a hero, a person who saw the suffering of others instead of looking away. He worked hard to correct it, to help any and every student. That is why a school's name should be one of a hero of history, not a... Yeah.
Thank you, Mr. Shruti Pratt. Megan Brackett?
Hello, thank you. So I'm just going to kind of include our timeline for what the parents and leaders did for this renaming. So the Equity and Inclusion Group, or EIG, worked for 1.5 years on this campaign in conjunction with school administration, faculty, and other caregiver leaders. Our group leaders met with the renaming committee led at Shirley Chisholm, ES, to learn from their process in September of 2024. The EIG shared the plan for the school renaming project at a school community meeting in November of 2024. Initial outreach to the school community via weekly newsletters began in January of 2025, and the EIG kicked off the process and outlined the reasons why we were renaming the school and a background explainer. Our community name suggestion survey was open February through March 2025. By March 4th, we had collected 57 name submissions. The EIG shared progress at monthly community meetings at the school on the name change process. In March of 2025, outreach to Councilmember Allen's office and ANC 6B commission began. The EIG reviewed community submitted names from March to April of 2025, narrowing the 57 names down to 8. All of the school faculty reviewed the short list of the names. 38 faculty provided input, expressing a strong interest in Elizabeth Catlett and Gardner Bishop. The EIG shared these finalist names at an April 2025 community meeting. The community learning and engagement around the two finalists began in May of 2025. We circulated information about the finalists to the community via email, on bulletin boards, and at posters at the school and at community gatherings. A multi-stage community vote to select one of the finalists began in May 21st, 2025. Every student at the school had the opportunity to learn about Elizabeth Catlett and Gardner Bishop in their classrooms and then vote for one of the finalists. The 4th and 5th grade students created murals and videos arguing in favor of the finalists. The Equity and Inclusion Group circulated an online voting survey to caregivers and alumni families, reaching hundreds of individuals who are or have been connected to the school, who live in the neighborhood. The final results after 2 weeks of voting and outreach were Gardner Bishop 378 and Elizabeth Catlett 339. The community is proud of this process, and we will be proud to have Gardner Bishop as the new namesake for the school. We ask for you to support this legislation, and we thank you for your work.
Thank you, Ms. Brackett. Leticia Rojas?
Thank you, Chairman Mendelson, for holding this hearing. And thank you, Councilmember Allen, for sponsoring the Gardner Bishop Elementary School Redesignation Act of 2025. As a current Brent Elementary parent and a member of the Equity and Inclusion Group, I have been involved deeply in the process of renaming our school. Over the past year, I was proud to see the commitment our school community showed in participating in the renaming process, from parents and caregivers, from the faculty and staff, and from the students themselves. The submissions we received showed us a wide range of individuals who align with our school values of bravery, empathy, action, and responsibility. Narrowing down the list was a monumental task for our group. With the input from the faculty, we were able to focus on 2 finalists, Gardner Bishop and Elizabeth Catlett. Finally, with the enthusiasm of our students as they learned about these figures, their ability to debate the merits of each of them, and their willingness to share their opinions, the community voted for Gardner Bishop as the new namesake for our school. Gardner Bishop was a parent who saw great injustice. Having his children forced into overcrowded schools when space was available but restricted to white students. He decided to organize his community in order to change these conditions. From 1947 to 1954, as the president of the Consolidated Parents Group, he fought for equality in education for all the children in DC. His work culminated in the historic Bowling versus Sharp case, which ended school segregation in the District of Columbia. After the decision, attorney James M. Navitt, one of the lawyers who won the case, said of him, "Mr. Bishop has raised the money, led the people, kept the organization alive. He was the guiding genius." As our school enters this new chapter of its history due to the modernization project, renaming the school will not only honor Gardner Bishop as an important figure in DC's history, but it will also be a reminder of the power school communities have in shaping the future of our country. On behalf of myself, my family, we ask you to support this legislation, and we thank you for your work.
Thank you, Ms. Rojas. Cortavia Freeman?
Good afternoon, Chairman Mendelson and members of the committee and Councilman Allen. Thank you so much for allowing us to speak on behalf of the renaming of Brent Elementary. My name is Cortavia Freeman. I'm the proud co-PTA president at Brent Elementary, and I'm here today on behalf of the families, educators, students to voice our strong support for the Gardner Bishop Elementary School Redesignation Act of 2025. As a school community, we took the moment seriously. With modernization underway, our building is set to reopen in 2027, and we asked an important question of ourselves. What do we want to honor? What values do we want our school name to represent? And what do we want it to represent for generations to come? Our students were at the center of this process, as you heard from Billy today. They studied the history, they watched videos, they debated, and they created murals that were beautiful and reflective of our school community. It is not lost on me as the PTA president that this is a majority white school, and there are very few Black students. However, the name that's reflective on top of the building is someone who would have inhibited their access to this school building. Through this learning and what Gardner Bishop did for African-American students and all students across the district, it deeply resonated with me. He was a father, a community advisor, a civil rights activist who refused to accept unequal education for his daughter. And he had the courage to persist, to fuel a legal battle that ultimately led to Bowling versus Sharp, a landmark Supreme Court case that declared segregation in DC public schools unconstitutional. That was not a symbolic process. It was a democratic, it was inclusive and transparent, just like our process, where students voted, families voted, alumni voted. And after weeks of engagement, Gardner Bishop emerged as the collective choice. Renaming our school is not about erasing history. It is about telling the full story of history and choosing to uplift a legacy that reflects who we strive to be: inclusive, courageous, and committed to equity. Gardner Bishop embodies those values. As the co-PTA president of Brent Elementary School, I say with confidence that this process has strengthened our community. I taught our children that their voices mattered, and it helped shape history. That justice is sometimes what we stand for, and it's sometimes hard and elusive, but with your support, this legislation will allow our school to move forward under a name that truly represents our mission, our values, and our future. Thank you for your time and your leadership, and we hope that you will be in full support of the renaming of Brent Elementary to Gardner Bishop Elementary School.
Thank you. Thank you, each of you, for your testimony. I do have a few questions. So at one point, there were 57 names, and then it was the faculty that narrowed it down to 8. Does that sound right? And then the 8 got circulated. Microphone.
A few names that were already being considered by other schools, or the names were in Baltimore, I believe. Some of the public schools were named in Baltimore and Northern Virginia, so we wanted to make sure it wasn't confusing in the DMV area.
It was the faculty that brought it down to 2.
It was the faculty and the EIG group, yes.
And then the 2 went to everybody, which includes the students.
Correct.
How broadly was the community around the school involved? The impression I have, you had a community meeting, so that suggests the community was welcome to participate.
Yes, that's correct. And we also reached out to past families of Brent, past faculty of Brent, and it was an online voting system.
We used neighborhood listservs to spread awareness so that people who lived in the community, whether or not they were Brent parents or had ever been Brent parents, could be involved as well.
At this point, is there any opposition to the name that you know?
We have not heard any opposition at this point or at any point during the process. It's been a very cohesive and enjoyable process.
And it was highly publicized, and at our last Rory event where we were in the building for the last time, we kind of came up with the final vote. So it was very widely known across the board.
Thank you. Councilmember Allen, do you have any questions?
Thank you. I do. First off, thank all of you for the hard work that actually got us here. Now it's our job to get over the finish line, but you all did the hard work over this past couple of years. Ms. Cheek, let me start with you. We've talked about changing the name of Brent for a few years now, and not just 2 or 3, like for a while. And those efforts never really kind of got off the ground or had the traction. So I think there was, for a long time, a recognition that there could be a more appropriate name affixed to the school. What would you say was some of, like, what helped make this effort successful? What helped get the buy-in? What was different this time compared to some previous attempts, if you remember the way it worked previously?
Sure. I think the modernization of the school was really the trigger that was needed to take it from a conceptual renaming to an actual renaming process that has, to this point, been very successful. We knew that with the modernization, we would be out of the current school building for 2 years. And upon returning, the building itself would look new. That seemed like the perfect opportunity to christen it with a new name. And I think we had a lot of community buy-in at that time.
Yeah. Okay. Excellent. To Mr. Shuti Pratt, you did a fantastic job with your testimony. Great job. I really focused in as well the way you talked about what you learned about Gardner Bishop, that he's somebody who saw that something wasn't right, and rather than just accept it and just kind of give up, he took action. He did something. When you think about lessons that you and your friends learn in school, are those the types of lessons that you kind of look to a school name and you say that kind of helps tell me the values of my school? Do you think that's the type of lesson will be taught in the school around that resilience, that ability to fight for the change you want to see?
To be honest, I just don't know.
All right. I have a hunch your teachers in your school is going to try to help teach who the school is named after and kind of the values that you see. I'll contrast that with, do you spend a lot of time in school learning about who Robert Brent was and what he did? Are those the values that you feel like your teachers have kind of taught you to emulate him?
No.
Good. Okay. All right. I think you're going to experience something where your teachers are really proud of the namesake of your school and help talk about who this person was, what this person did, and let those be values that you all learn as kids too. To Miss Brackett, you talked about reaching out to the Shirley Chisholm School community. Can you share a little bit of what did you learn from their process that then helped inform the process that the school community went through?
Yes, the folks at Shirley Chisholm were really, really helpful with our process. They really wanted us to make sure that we were seeking support from the whole community, not just parents at Brent. And they were very gracious and documented all of their steps that they took to do their renaming. We've now done the same thing. So any other schools that want to go through a renaming process, we kind of have a semi-formal process of how this works. But yeah, they wanted to just make sure it was really well communicated, that we really thought through who we were going to rename the school after and how the community was involved to do that.
Okay, great. I'm not surprised. And having worked with them through their name change, I really think you guys did a phenomenal job of a very thoughtful, inclusive process that led you obviously to this. Ms. Freeman and Ms. Rojas, I mean, it was a tight vote, right? 378 to 339. Anything you can share just about kind of how did it, was there any lingering issues of the folks that chose Elizabeth Catlett? Were they hanging on and saying, maybe we'll do a recount? Or did folks say, you know what, we had two great people to choose from, and so everyone got on board with Gardner Bishop? Anything you want to share just about kind of going from a relatively close vote to feeling like it's a fairly unanimous decision here?
No, I don't think there was any. I think all of the children were very passionate about who they wanted, but they also knew that either one of those people would be, they would be proud to have their school named by them. I think the same could be said from our community. I don't think anyone was like sore or anything. We just like joined together and celebrated that that the decision was Gardner Bishop.
Yeah. And Ms. Freeman, anything to add to that?
I voted for Elizabeth Catlett. She, as a lover of the arts, I mean, her career has been phenomenal. So obviously I would, as an African-American woman, have wanted her name to be bearing. However, it was my daughter, Mackenzie, who's a second grader at Brent Elementary, who swayed me through their rigorous debate about Gardner Bishop and what he did, which led our whole entire family go and to learn. Elizabeth Catlett had an exhibit that we visited. And so it really it was a life learning lesson for our family. We love African-American history. So it was just amazing to see all of the effort that he put forth as not someone of the traditional track to go before the Supreme Court and to be able to fight, to legislate, to get something done for his children. So it swayed me. And I think many in our community feel the same way. So I think nobody feels sore about it, right? But I was a fan of Elizabeth Catlett.
That's fantastic. Well, I appreciate everybody's hard work to actually get us to this point, to show up to the hearing here. I appreciate all the work that you've done, and I'm excited about being able to move this forward so we can actually make this name change in time for welcoming us all back to the new Gardner Bishop. Thank you.
Thank you, Councilmember. Thank you, each of you, for your testimony. And I'm going to turn to the government. Abraham Clayman. I'm trying to see if we can move this along, so I may look a little impatient. If I'm not successful, Councilmember Allen will take over, but don't want that to happen. So
Okay.
please proceed.
All right. Good afternoon, Chairman Mendelson, council members, and members of the public. I'm Abe Clayman, the Deputy Chief of Intergovernmental Affairs at the District of Columbia Public Schools. One part of my job at DCPS is advising school communities about the legislative process when they want their school formally named or renamed. Thank you for the opportunity to testify today. DCPS supports the school community's selection of Gardner Bishop. As others have shared, Bishop was a native Washingtonian, local business owner, an advocate for equal and desegregated schools. It is fitting to name the school after him. Fortunately, the name change can be incorporated into the school's modernization without a fiscal impact if it is enacted by July of this year. That will allow sufficient time to procure materials for the project. Thank you to the students, educators, staff, parents, and community members who worked to arrive at a choice for a name. For the past year, the school community has been discussing a new name for the school. They collected submissions from the broader community, narrowed a lengthy list, and ultimately voted. The community, students, families, educators, and staff led the process to determine the future identity of their school. Thank you, Chairman Mendelson and Councilmember Allen, for your work to advance this legislation and for holding this hearing today. The DC Council is entrusted with the responsibility of naming public buildings, including schools, and this naming would not be possible without your support. On behalf of DCPS, we support this selection of a new school name. I look forward to your questions.
Thank you, Mr. Clayman. I do have a few questions. So if we adopt the legislation over the next couple of months, there will not be a fiscal impact.
That's correct.
Has DCPS connected with the Bishop family?
Not to my knowledge, or at least the school system has not. I'm not aware of whether members of the school, like the parents or educators, have.
Is there any issue with the name change and the lottery?
No.
And can you comment what DCPS is thinking with regard to any additional schools? The FACES report, which was a draft report, identified 19 schools. We've renamed what? 4, including this one?
Sure. So I think our perspective with that is that if a school community is interested in renaming their school, we're going to work with them to help them understand the process. In the case of Brent and in Chisholm, we've provided them with resources to say, this is what has worked at other schools, or advice about this is what has worked at other schools. currently Seton Elementary School is interested in pursuing this. I think you've heard from folks about Sharp Health School. And then, of course, we're opening a new school on Euclid Street, a new middle school. So those are the three schools that are also considering this right now in one form or another.
Okay. Councilmember Allen?
I think the chairman covered most of that. So July is when you just need to have it so that from a purchasing procurement standpoint, there's no delays, no extra costs.
That's correct.
Okay. And for the current swing space, which at least right now I think is titled Brent Elementary at Meyer, for the swing space terminology for the moment, do you need to make any changes at the swing space location, or would DCPS prefer to leave the swing space as Brent and then have Gardner Bishop officially take effect when we move back? Do you have a preference on that?
That's a good question. I'd want to check with the team about that, because I think there could be both from the lottery perspective and also the signage, there could be some implications there. So
okay,
I don't have an answer for you today, but we can follow up about that.
There's no permanent signage at Meyer though that says Brent. It's
is there anything on the front of the building? I can't.
There's a sign, right?
There's a metal.
Okay.
There's a metal. Ms. Freeman said there's a metal sign on the front of
Okay.
the building, so that's something to think about.
Semi-permanent. Okay. Okay. All right. So preference would be that at the swing space, what I'm seeing from it is, yes, they would like to change it. Okay. So happy to talk with you after the hearing, and we can figure out how we can help effectuate that change. Likely it'd be the type of thing that would happen over the summertime, so that for the beginning of the new school year, perhaps there's new signage there.
I will gather some information and get back to you, but I hear everyone here loud and clear.
Got it. All right. Fantastic. I think the chairman covered my other questions, so I don't have anything else, Mr. Chairman. Thank you.
Then we may be good. As I indicated at the beginning, the record in this matter is open for 2 weeks. That is, it will close at 5 p.m. on January 27th, 2026. Anyone wants to submit anything additional? Anyone who hasn't testified or comments wants to, you have 2 weeks to do so. I want to thank everyone for their testimony and their patience, since this hearing started about an hour late due to the previous hearing. The time is 3:45 p.m.